and the PM USHA MERU component. As you all know, yesterday we had an enriching and insightful beginning where we explored some very important aspects of research practices. Today, we are equally excited to continue this journey of learning and discovery with fresh perspectives and valuable sessions. On behalf of the organizing team, I extend a warm welcome to the resource persons of today's session, Dr. Rudresh M, Associate Professor, Dayanand Sagar Engineering College, Bangalore. Welcome you, sir. I even welcome one more resource person of today's function, Dr. PraveenKumar MB, Associate Professor, PM University, Bangalore. Welcome you, sir. I welcome Professor Shivanand, Chairman, Department of Computer Science, who is the coordinator today of our sessions. We welcome you, sir. I extend a warm welcome to all the distinguished faculty members and research scholars who have joined us this morning with the same enthusiasm as yesterday. Your active involvement is what makes this workshop truly meaningful. Let us look forward to yet another day of knowledge sharing, thoughtful discussions, and practical insights that will surely inspire and guide us in our academic and research endeavors. Now we move on to the session 1 of day 2, which will be conducted by Dr. PraveenKumar, Associate Professor, Department of Computer Science and Engineering, PM University, Bangalore. This session will be coordinated by Professor Shivanand Gonale, Chairman, Department of Computer Science. I request him to carry on the session.
So, very good morning to all of you. So, this is secondary first session. Dr. Praveen and Dr. Rudresh are going to handle today's session. So, one thing I am going to tell you just about the Praveen and Rudresh, as already you know, yesterday's mail biodata and all those already know. But one thing I am going to tell you, so both they are from the mechanical engineering background, and now they are in robotics and automation and art. Usually they are very expert in filing the patent and how to draft the patent. Even up to the level of the granting of your patent. So they are going to deliver you how the patents are filled. Okay, what is the filing process? Because we have the ideas, but sometimes we are not able to how to file it. Okay, so what is the first examination report? How to write the query? Okay, how to write the compliance of that one. So, for example, in the first examination report, they have some observation. How we are going to comply those observations? The most important part. Many of you might be knowing that whenever you are submitting the research papers, the reviewer comments you will get it, and usually we will comply with the reviewer comments. That is, we call it as a response statement. But here, the somewhat different things are there. Because we are going to file a patent, so because we are inventing, we are innovating, or you can say we are inventing a new things, so that's we are filing here. So now today's session, both they are going to have some hands-on experience also. So they are going to show you how the patents are going to be filed and what are the different types of patents. Already yesterday you might be knowing this, and today so you will get. They are going to give the details thing with the sites and with some hands-on practical sessions here. And the most important part is how to draft the patent document. That is the most important part. Okay. So already we are drafting our research papers. That is different. But how to draft the patent? So that is the most important part. So today I think Praveen is going to deliver on this session on this how to draft the patent. So, Praveen, the session is over to you. Please take over charge of it. Good morning, everyone. Okay. Today we are going to show you how to draft the patent. Okay. Patent trust and patent draft. Okay. Already yesterday Rudresh told what exactly is a patent. Okay. You need to protect your ideas. Okay. So you need to protect your ideas. That's the reason we are going to file a patent. So probable questions and also the answers. Okay. The first question, okay, which act governs the patent system in India? Okay, so every country has their own patent laws and they have some acts also. So India, we follow the 1970 Act. Okay, 1970 they made an act for India. Does patent give protection worldwide? Whatever we protect the patent, okay, it protects worldwide. So I need some answers from your side. Okay, so that will be good. So whatever we are going to file a patent, okay, whether it can be protected to the entire world. Yes or no? Yes? No?
Yes, no.
No? Okay, fine. Correct. So no. See, because whatever we are going to file, okay, if you are filing in India, that protects under Indian system, not to the other countries. It is very clear. So if you want to protect under other countries, the next question, when to file the patent for the same invention in other country? So if you want to protect in other countries, what we need to do? I told you yesterday, okay, there is a act called as PCT. Okay, you need to go and file under PCT, but usually academics, okay, we don't do. But if it is very novel and if there is a commercial involvement is there, definitely we need to take a support in filing, in registering under PCT. PCT covers around 150 countries. So no need to go and file a patent in individual countries. So one file under PCT covers 150 major countries. The next question, okay, how many countries should an applicant file patent? How many countries? So patent should be filed in each country. For example, if you are not filing under PCT, okay, 150 countries, okay, your product or the idea, okay, which has a major revenue in 3 to 4 countries. For example, India, China, and Europe. Okay, then you need to file a patent in India, China Patent Office, and then the European Patent Office. So this will protect duplication of other people in those countries only. So other people definitely they can copy your idea and they can replicate the product also. So whichever country you are going to file, that country you are going to protect. This is very clear. Okay. So what we learned, okay, wherever you file a patent, your patent is protected in that country. If you want to file the worldwide, we have an act called as PCT. 150 countries will come to the picture. And whichever country you are going to file, okay, that particular country, your concept or the patent will be protected. So the next question, when should an applicant for a patent be filed? When you need to file a patent? I asked you yesterday the question, okay, you have done some research, okay, and you have published your journal also, okay, after that people go for the patent. Is it right? No. So it is a wrong, because publication can be done, okay, whatever patent you are going to file, okay, I told immediately once you file, publish will happen, okay. During the publish, okay, no one sees the novelty or whether it is copied from other people, okay, or already it is available in the website, okay. So they will just publish it. During the examination, okay, they will check for the patent search, novelty, duplication, everything they will try to check, okay. During that time, okay, if it is already published in your own journal also, so you cannot protect under patent. You can claim it, sir, this is my journal, okay. So again I am going for a protection under patent. It cannot be done. If it is your own journal also, because already it is in public. So again you cannot go for a protection. When it should be filed? Okay, I told you yesterday, okay, you have started some research, okay, you will come to know that, okay, the research is novel and nowhere it is available. So immediately what you need to do is, okay, patent search you need to do. If it is not available, immediately, okay, if it is not completed, research is not completed also, you can immediately file your idea or the concept in a patent office. So no need of completion of a prototype. Prototype
no one will ask. No one will ask for the results, observation, calculation. Nothing is there. Okay. Especially in the patent, you are going to protect your ideas. You are going to protect your ideas. So one more thing is, okay, never put any dimensions, never put any values, never put any material specification. That is not at all required. Because if you are writing, okay, for example, 50 mm, okay, what some product you have developed, okay, you will give all the dimensions, 50 mm, 500 or 30 something dimensions. So other can prove that, okay, whatever you have done, okay. So compared to that, okay, they will prepare a same model and they have done, okay, 31 mm, giving much more result, best results. So that is the reason. Anyway, in the patent, you see only the drawing picture will be there and label of that. No more, nowhere the dimensions will be written and also the material composition or the specification. So don't do that. Okay. So whenever you try to do any invention, okay, immediately the concept should be, patent should be filed. And I told you, okay, so once you file it, okay, 12 months of time is there to complete this one. Once you, before 12 months, okay, the complete specification of the concept to be filed one more time. So, can any invention be patented after publication? Okay, I have already addressed, okay, it cannot be done. So, what can be patented? And what cannot be patented? Okay, so both are there. What can be patented? An invention is, so I want you also to read it so that, okay, you won't forget. Okay, an invention is patentable subject matter if it meets the following criteria. What are those criteria? One, it should be novel. So it should be novel. No duplication, no copycat, no nothing. It should be for the first time. Whatever you do, it should be for the first time. And whatever you are doing, okay, there should be an inventive step. This is very much required because, for example, okay, I will show you the example also. A and B, okay, they have filed a patent. Okay, so at the same time, but the patent office looks for the inventive steps because you will be discussing with your colleagues or with your friends on whatever the invention you are doing. But the inventive steps will be known with you. But they know only the concept and they will also try to put a patent idea and they will try to protect under patent. But when it goes to the exam there, okay, he says, okay, both are similar. Then he goes for the inventive steps. So inventive steps are very, very important. So when you are drafting a patent, okay, the steps of the procedures are very, very important. Make sure it is having an inventive step. And it should be capable of industrial application. What is industrial application? So you have a concept and that concept to be commercial. Okay, for commercial in the sense, production to be happened. Okay, so people will come with very big, fantastic concept which cannot be manufactured at all. It should be easily manufacturable also. Whatever the idea you have, the concept, so it should be easily manufacturable. If it cannot be manufactured, it is not waste. It is like a tree. So whatever you have a concept, okay, it should have an inventive step and it should be easily manufacturable. So what cannot be patented? This is very important, okay. So an invention which is spurious or which claims anything obviously contrary to well-established natural laws, okay. So what is the natural law? Okay. So there are certain natural laws, okay. Any mission, okay, to be run, okay, you need an energy or the power source. So your idea tells that, okay, we don't require anything else. So that is against the natural law. You cannot do it because any mission, okay, any equipment that needs energy. So without energy, can you run? Highly impossible. For example, a car, any vehicle, okay, it runs on whether diesel, petrol, or electric also. Without that, can it run? Highly impossible. So it should not be against the natural laws. An invention the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious to human, animal, or plant life or health or to the environment. See, what does it say? Your invention should not cause any damage to the environment, animal, plants, and the human beings. That invention cannot be protected under patent. You need to be very careful. Mere discovery of scientific principle or a formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. Okay, so what does it say is, okay, we know about the gravity. Correct, right? Apple from a tree, it comes down because of the gravity. So again, no need to prove that, okay, that cannot be protected under the patent. A substance obtained by mere admixture resulting only in aggregation of the properties of the components thereof a process for producing substance. For example, you have a water, you have a lemon. When you squeeze it, okay, it becomes a lemon juice. That is common phenomena. So when you add 2 to 3 substances, okay, it forms the known thing. Okay, that cannot be protected. Understood, right? Or mere discovery of a new form of a known substance which does not result in enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use for the known substance, or the mere use of a known process, machine, or apparatus, unless such known process results in a new product or employs at least one new resultant. Okay, so what does it say is, okay, already we have many crystals or other forms in the nature. Okay, so those crystals, okay, again no need to say that, okay, we have discovered a new thing. Okay, so that never comes under the patent. A mere arrangement or rearrangement or duplication of known devices, such functioning independently of one another in a known way. What does it say is, okay, for example, okay, torch, it has already invented. Watch, it has already invented. And one more device, mouse, already invented. So you are joining all the three, but it is functioning independently. So you cannot say, okay, torch is already invented, mouse is already invented, watch is already invented. Okay, so when you join these three, and you will form a new product. You cannot protect under a patent. That should be totally new. So when you join the available components and you say, okay, this is my new invention, it cannot be protected or it cannot be claimed. A method of agriculture or agriculture. So whatever we are doing, following from the years, okay, so the way we cultivate the agriculture, it cannot be protected. Any process for medicinal, surgical, or other treatment of human beings, or any process of a similar treatment of animals to render them free of disease or to increase their economic value or that of their product cannot be protected. See, the way the doctors do the treatment, okay, it cannot be protected under the patent. But the surgical instruments or other devices, it can be protected under the patent. Not the way they do the surgical thing. Okay, it cannot be done because there is no law telling that, okay, you need to do a surgery like that. So if there is any patent like that, okay, you need to cut like this, you need to open, it cannot be done because each and every individual has a different type. It cannot be, the process and procedure cannot be patented. Whereas the surgical equipments and all other things, can be protected, not the process and the procedure. Inventions relating to the atomic energy. So creating a bomb or anything, okay, it cannot be because it goes to the enemies and they can also redo the same. It cannot be protected. But why? Because, okay, once you patent it, it is available for the public. Public can have a look on how the preparation of this atomic energy and then they can also recreate. So such things, okay, even in the industry, okay, which is very confidential, we don't protect under the patent law. Okay, we do only the internal. So because once you public to the known to the public, okay, anyone can duplicate it. So even in the industry, even in the government, DRDO and the ISRO, they won't protect anything under such things under the patent. Plants and animals involved or any part thereof other than microorganisms, but including seeds, varieties and species, and essential biological sources for production or propagation of plants and animals. Okay, any new breed of plants, animals cannot be protected. But what Rudresh told yesterday, okay, it can be protected under agricultural, different there is a form, not under the patent. In the agricultural variety, it can be protected, not under the patent. A mathematical or business method or a computer program, it cannot be protected. See, any business, whatever the people are running, it cannot be patented, okay? The process, procedure, the decision, okay, it depends upon the individual. So such things, okay, for example, okay, Marwadi guy will be running a business, okay, so they have their own logic. It depends upon the individual perspective, okay, so it depends upon the style of working, their business calculations, okay, this cannot be protected under the patent, okay. A literary, dramatic, musical or artistic work, it cannot be. Whatever the films, movies, whatever we see in the TV, it cannot be protected under the patent. A mere scheme or rule or method of forming mental act or playing game. Okay, games cannot be protected. Cricket, football, this cannot be protected under patent. Or topography of integrated circuits. Yesterday we showed the circuit, right? IC circuit there. It cannot be protected under the patent law, but under the IC circuit, it can be protected. So agricultural integrated circuits, okay, these can be protected under different, not under the patent. That we need to be very careful. So coming to the patent draft, okay. So I told you it is not very difficult like journal, okay. Very few steps are there. So oftenly me and Rudresh will get a complete journal, okay. So faculties or the research scholars, they would have done an excellent journal and they will send directly to us telling that we need to file a patent. See, whatever the journal you are preparing, okay, that is totally different. That is a requirement of a journal, okay. The tables, calculations, okay. So those things are required only for the journal. But in patent, not like that. Okay, we need only these things. Title of the invention. So title remains same even in the journal and then in your patent. But whatever the journal title you are putting, it should not be the same for the patent. You will put right study and investigation of so and so. That is not required here. Okay, it should be very simple. Within 3-4 words, it should consist of only 3-4 words relating to that area. Not the study, investigation, and then experimentation of so that is not at all required. That word is good only for the journal. For the title for patent is totally different. Okay, we will see in the. I have taken one example. There we will have a look. The abstract. It is similar to the journal. But in a journal, you will be writing 200 words or 1.5 pages. Okay. Here it is not so. You require only a few words on what exactly you are going to work. That also we will be seeing covering in the next one. Drawing, it is very, very essential. So you put a drawing and label. No labeling of the this one. Okay. You are going to put a serial number. And then below that, okay, 1, 2, 3, 4, whatever the serial numbers are there, you are going to mention what exactly is 1, 2, 3, 4. And background of the invention. So what is the background of your invention? Whether it is related to the agriculture, whether it is related to the automobile, whether it is related to any machine. So what exactly is the background of the invention? Because when people are going through your patent, okay, so they see which area of invention you have done. According to that area of invention, they are going to assign your patent to the expert. If it is automobile related, they will assign an automobile related expert. If it is related to the agricultural. So that will help there. Summary of the invention. No need of writing 3-4 pages. Summary should be very short and sweet. Okay, that also will cover. Brief description of the drawing. Whatever the drawing you have mentioned, okay, you need to connect, for example, head, neck, body, hands, legs. Okay, how it is interlinked? Head is connected to the body through neck. Head is 1, body is 3, neck is 2. So 2, neck is connected to the head and to the body. And your hands are connected to the body. For example, hand is 5, serial number 5. So serial number 5, in the bracket you need to put hand, is connected to the body, which is serial number 3. Okay, so you need to give a connection in the brief description of the drawing. Then detailed description of the preferred embodiment. Okay, you need to create a detailed description, that also will be. And finally the claims. Claims are very, very important. So maximum people get rejection in the claims. So make sure, okay, your claim is very, very perfect. Okay, so claims matters a lot. That is the reason. Okay, claims cannot be okay. The patent comes under the law. Okay, so most of the people who have done LLM under patent, okay, they do this. Okay, it is also like a protection. Okay, so how the lawyers will oppose in the court against their own case. Okay, this claim will protect you against your patent or the whatever the concept you have filed. Henceforth, okay, make sure the claims are well defined and well protected, so that there is no discrepancies in the later stage. So we'll take a quick example on one of the products. This is known for everyone. That is the reason we have taken this. You have seen the Coca-Cola bottle, right? Pepsi, Coca-Cola bottles everywhere. Okay. So earlier days, okay, to open the lid, okay, it was very difficult. Correct, right? So what Coca-Cola did is, okay, they designed their own lid, how to open it, and they launched to the market. Okay. So I told you yesterday, okay, some people, okay, in the market, okay, what they do is, okay, once any product is launched to the market, they will buy the product and they will see what are the flaws. Flaws and the errors. Any error is there. So these people, okay, they identified that, okay, whatever the lid the Coca-Cola and Pepsi have done, okay, there are flaws in opening it. It is very difficult. And what we usually do 20-30 years back, we open it and we tear this one lid and throw the part aside and then we used to drink it. That was the usual practice we do. But these people, okay, what they do is, okay, they have a team and they will sit, brainstorm it, and they will see how to make it very simple and easy. One thing is very simple and easy. Even a small children should open it. Okay, not a big adult people. Even a small children should also operate it. So they will brainstorm and they will form a new design. And also, it should not affect the environment also. I told you that it should not affect the environment. That is also one of the points. Okay, they will see how easy it should open and how economic or easy to manufacture and how it is protected to the nature. So they came with the concept of a simple lid and they gave this concept or the idea to Coca-Cola and Pepsi. So all these companies have the same lid. So and they gave the design to them, and as a royalty, whenever this Coke or Pepsi or Fanta, they sell one can or one tin, okay, they get a royalty. Can you see? As a royalty, rupees 1.2 crores per day. These people they don't have any company, when they have a company, they don't have huge investment, no missions, no nothing. 3-4 people, they sit, they brainstorm it, and they come with a wonderful concept. Okay, and they are earning every day 1.2 crores per day. This is one example. Likewise, okay, most of the Japanese, okay, they work similarly on all the products, and they try to come with a solution, and they give the idea for each and every product. So that is the reason you will see a major change. Whatever it is when the product is launched, the first version, you will see a second version completely new one. So most of the people will wait for the second version because whatever there is a flaw, even the mobile phones, okay, there will be an error, okay. The new updated version will come in the second or any automobile, okay, there will be an issue in the first stage. After 6 months, okay, they will come with the idea. Their own people or some people from the outside, and the updated second version will come with the updated new things. Okay, that is the reason most of the people won't buy any product when it is launched. They wait for 6 months to 1 year, okay, to get all this correction. So coming to the patent draft, okay, I want everyone to read on your own so that okay, you will try to understand. If I read, okay, you won't read it, okay, you won't understand because these are very, very important. See, title of invention. You saw right in the journal how we people usually do. Not only you, we also put many things, okay, 3-4 sentences or 3-4 lines we put, okay. Easy open wall. See, it is a generic title. It is not related. Nowhere they have written. It is related to the Coca-Cola. It is related to the Pepsi. Nowhere it is written. A generic, easy, open wall. That's it. It should be same. Then abstract. Okay, I want everyone to read. An easy open construction for a container wherein a panel principally defined by a rupturable core line in a wall is opened by operating a tap having one end adapted to press against a panel at a position space from the core line and overlying only a small portion of the opening left by a panel in its open position. The other end of the table, liftable. So you have seen right, the other end. Okay, first you will rotate it and you will try to lift the lid. The same thing you have described. The other end of the table, liftable to open the panel and returnable directly to its original position next to the wall. You will rotate, open, and again it is retracted to the same position. The tab and panel remain secured to the wall after the panel has been moved to its open position. See, this is the abstract. No need of writing 1.5 pages. Okay, well defined a small description of what you have done. Nowhere is mentioned the company or where it is used, beverages, nothing. It is generic. So why? Because if you try to mention we are developing a product for beverages for Coke or Pepsi bottles. So other people, other than this, okay, oil can or something else, okay, water bottle, something if they are producing, okay, this never be protected there. So this is a generic, so that okay, it is applicable for all types of industry, not only for beverages, even for the food or anything else. So your abstract should be generic. So these are the drawings. So no dimensions, nothing, okay, a small figure of each and every angle, top view, bottom view, side, left side, right side, so all the sides, and then you need to mention figure 1, 2, 3, 4, 5, 6, everything, and nowhere else mentioned, okay, this is a lid, this is a can, nothing, 1, 2, 3, 4, you need to mention, okay. This is a complicated drawing, but whatever we are doing, okay, it will be simple. If it is complex also, you need to maintain the same. And below this drawing, okay, you need to mention what exactly 1, 2, 3, 4, 5, 6, 7, 8, 9. So that helps us, gives us brief overview of the drawing. Next one is the background of the invention. So this is very important because people will try to understand which area you are going to protect. Large number of containers, food containers, particularly beverage cans, are conventionally opened. See, this is what I told. What is the problem statement and what is the solution, technical solution you are giving, okay? Large number of containers, particularly beverages cans, are conventionally opened by pulling of a tail strip which is removable together with the detached ring tab. Earlier there was a ring and they will try to pull it and throw the ring. The severe tail strip with attached tab may be carelessly discarded with undesirable consequences such as litter and hazard to bare feet. just thrown outside. Moreover, many cans with easy open ends of this sort are made up of aluminum alloys. Usually the cans are made up of aluminum alloys, which can be produced with less expenditure of energy through recycling. The aluminum can be recyclable. So, and the metal in the tail strip and the tab are more readily collected and recycled if the tail strip and tab remain with the can body after opening of the can. We are told very clearly earlier, okay, they are going to tear it and throw to the environment. Okay, this is very hazardous and also causing the problem to the human being when they are stamping on that. Okay, this invention has made that, okay, you are not going to remove from the can, so they are going to by a process and they are going to, it remains in the can itself. The container industry is highly competitive and has long made serious efforts to design easy open can ends, particularly of the kind used to contain beer and carbonated beverages, so that tail strips and tabs could be secured, not detachable, while still remain convenient to operate and use and free of substantial cost penalties. These efforts have produced many designs, but none before the present invention appears to have a provided solution to the problem accompanied. So you are told what is the problem and you are given the solution or what area you are going to work. This is the background of the invention. So whatever you are doing, it should be the same. So address the problem and you tell this is the solution and no one has addressed till date. Detailed description of the drawing. You saw what is figure 1, 2, 3, everything is mentioned, right? For example, okay, figure 1 is a perspective view of a container of this invention with the center and the bottom portion they are broken away and illustrating an easy open wall of this invention provided as a top wall of such container. See, each and every view you need to explain what exactly the view you are showing. So description of the illustrated embodiment. I told you, right, I gave the example of head, neck and then the body and how it is connected to the hand. Okay. Similarly, you are seeing, you can read it here, the figure 1 to 13 of the drawing. The form of top was 21K, which is made in accordance with the teaching of this invention. The remainder of container 20 may be suitable conventionally constructing and includes a bottom wall 22. Say 20 is a container, 22 is a bottom wall. Okay. So 22 bottom wall and the side wall is 23. So the description of illustrated embodiments, it includes that how it is interconnected between each and everything. Okay. Any product, okay, it is interlinked with each other. How it is interlinked, you need to show in the description of illustrated embodiments. See, this is nothing but the inventive step. Understood, right? This should be very carefully drafted. This is what the patent attorney or the final approval examiner sees this. There should be inventive steps. How it is interconnected, how it is easy to manufacture. These things they will see. Claims. So claims are very, very important. As many claims you write, okay, don't try to put 1 or 2 claims. Try to put more claims so that there will be a hold on your whatever the concept you are finding. Okay. The first claim should be very detailed explained. Okay, you can read on yourself. Okay. It should be detailed description of this one in the claim 1. Claim 2, 3, 4, 5, it should be interconnected to the claim 1. Okay, we will have a glance on how it is because it takes hardly 2 to 3 minutes. Claim 1, an easy open container end with non-detachable means for making an opening there through suitable for pouring comprising. An end wall, a rupturable score line in the end wall, defining most of the periphery of a non-removable tail panel while leaving an integral inch between the panel and the remainder of the end wall. Set score line extending away from one end of the inch around a bright where it is distant from the inch and the back to the other end of the inch. A tab extending generally parallel and close to any underlying area of the end wall, a rear part of the tab being engageable for upward lifting and forward part of the tap overlaying a minor portion. So this describes a clear how it is connected between each other. And I gave the example like neck. So on one end of the neck, your head is connected. On the other end of the neck, your body is connected. Similarly, he has explained how the lid will be operated and how it is held in a container. It is detailed explanation on the claim 1. Claim 2 tells 2, 3. I will go to the 3. It is simple. The structure defined in claim 2, wherein that attaching means comprises the rivet initially formed in about the center of said main wall. So each and every component or how it is operated, you are going to claim it. For example, I told head. It is connected to the neck. In the head, you have many other components. Or this one also. Eyes are there, nose, ears, hair, everything is there. So in the head, claim 2, 3, 4. You need to say that in the head. These are the components, how it is interlinked and how it is connected. Clear, right? So claim is very, very important. And also the description of the illustrated embodiments. These are the inventive steps and claim is what you are going to claim. See, for example, many times what happens, you have an idea and we think that nowhere in the world people are done on this, whatever you have done. So you will try to think, no people have done, so straight away I will go for the patent application. So what happens is, don't think like that, because any in the entire world, whatever we think, already people would have applied long back. For that, we need to go for the patent search. I will touch upon what exactly is a patent search in future. Future slides. So what I will tell you the trick, what to be done. Already your idea, what the thought process is in your mind. You will think, no one has copied, and this is for the first time. You will do a patent search. How to do a patent search? We will show you. So while doing a patent search, you will come to know already your idea has been someone has done already long years back. 2 years, 3 years, 10 years, or 20 years back, already this idea has been done. But for you, it is coming for the first time now. So when you do a patent search, you will come to know it has already done. So what should be done is, you need to copy the patents, whatever people have done, and go through each and every steps and how they have done. There you will find some flaws or the error which is not claimed, which has not been protected. But definitely whatever your idea is there, it won't match exactly 100%. Some part, there will be a scope for improvement, or there will be a scope for filing a patent. Then what you do is, same idea, you apply a different this one, apart from whatever he is claiming. Clear, right? Because if you are claiming 100% what he is claiming, then it will become a serious issue. So you will get a notice telling that already the product or the idea has been registered. You are copying it. So you will get a FIR report saying that everything is there. So for that, what we need to do is, before filing, you need to do patent search on your own. Patent search before filing. As an attorney, or we do that. That is the final one. That is our scope. Before that, we always recommend the people who are inventing or those who want to protect, you need to do a patent search on your own. So when you do a patent search, you will find a gap. What exactly the gap is there? So only for that gap, you need to provide a inventive step and file a patent. Don't think, already it has been protected, and don't think like, why we need to protect. Definitely there will be a scope for improvement. That improvement, you need to see how you can protect and how you can go for a patent. Clear, right? So patent search types, when you are searching, so there are two types. One is free version patents. One is a paid version. Okay, paid version we cannot pay that much amount. Okay, so only the accountants will be having because they do this activity every day. So the free version it is available open for all. So anyone can access and you can have a look on whether people have done on the same work or not. Okay. So what exactly you are going to see? Whether it is novelty search or patentable search. Okay. Whether there is a novelty. If there is a novelty, yes, you are eligible to go for a patent. State of art search, whether people have done already, what exactly they have done. Okay, all these searches you need to see. Or which field of area, all these things you need to see. Invalidity search. Invalidity search also says that, okay, so invalidity search says that, whether it can be applicable in which area of the field. Okay, if it is for the different, that will become invalid. Whatever the product or the patent you are applying, it should be to some field. Okay, if you are applying the same this one for some other field, it is invalid. So freedom to operate search. Freedom to operate search. Says that already it has been done or not. Many people have done the work. Those searches we need to do. Landscape search. It tells about the, I told you right, whether whatever the concept we have, it should not become like it should be like easy to manufacture because, for example, Wright brothers, invented the aeroplane, at that part of time, people said, you are a mad guy. So this cannot be done. See, Wright brothers have an idea of like, this definitely will help. And definitely there is a future. But at that point of time, other people were not aware, this will happen or not. So that also you need to see. Over the landscape, whether it is happening or not. Or sometimes what happens is, whatever you have invented, that might not be useful for now. Definitely after 50 years or 100 years. So that also we need to have a look. Assignment search, transfer of all parts to the arrangements. You also need to see who owns, for example, some people have the patent already. So how to collaborate or do like that. Some means, I will show you the example. The same, for example, the light. People have applied a patent. For the tungsten, inside we have a tungsten, right? So you can do multiple patent on that. So how to combine with those guys? That also we can have a search. And novelty search. Look for all the prior arts, not restricted to claim any part of the complete specification. So that also will kill your invention. Non-patent literature, for example, I told you already you have published a journal, book, or the story, film, movies that cannot be protected. Should be done at multiple stages of result. So whatever you do, I told you right, you can add also in the future. So we have applied for a patent. In the future, you can keep on adding your ideas to the same patent. That can also be done. To be done by the IP professional before patent filing. Whatever you do, you will do for your own this one. But finally, whatever you are applying, that should be gone through the patent attorney. So this is the example which I told. A famous example to understand the different aspects of patentability is the bulb and the filament example. In the example, an invention of electric bulb with a metal filament had received a patent, hereby referred as patented. Already people have applied on a bulb. So bulb consists of electric bulb and a metal filament. Only two parts are there. Too many parts are there. But these are the two areas where we can apply for a patent or there is a scope for a patent. So patent A has applied already. In the forthcoming year, coming year, B, the person B applies for a grant of patent for using a tungsten filament in electric bulb. So earlier, filament bulb, they are not done using a tungsten filament. Later stages, okay, people will come with the innovation, so tungsten filament can be done. So he also applies for a patent. What happens? We'll see. In such a situation, the patentability search would be conducted in a strategic way. So it will be evaluated in a proper way. Okay. To concentrate on aspects of inventive steps. I told you, right? So whichever the patent they receive, they have an inventive steps. As the other two aspects of novelty, and there should be a novelty and an industrial applicability. Means novelty should be there, and it should be also be easy to manufacture. Okay, this should be satisfied. Only three things: one, it should be novel, and industrial applicable, means easy to manufacture, and there should be inventive steps. If these three are there, it will be patent will be awarded. So whatever we apply, it should consist of all these three. Documents which prove for against the presence of inventive steps will be the main objective of the patent report. The process that we follow for our patent search projects involves a searching team of 3 to 4 people. So, like in journal, okay, 3-4 reviewers will go through our journal, right? So, in the similar, okay, even in the patent, okay, 3-4 experts will be there of that particular domain. They go through each and every aspect and they give the summary of the A and B, whatever they have done. Okay, each case in detail to strategic a plan of action for the search. The search is then conducted on both paid and non-paid sources. So whatever search you are doing, it is paid version. Non-paid version. In the paid version, okay, each and everything will be captured. Okay, paid version is an extensive version. It is used only in the industry. Okay, to get a closest match prior art document. We then review and analyze the results to categorize the relevance and then provide a detailed report. This report is then assessed by our analyst to check for the quality and relevance, and a viable conclusion is presented in the report. This is nothing but a FER, first examination report. The examiner will go through each and every this one with respect to all these three: novelty, inventive steps, and industrial applicability, and then they give a FER report to you. So that FER report, we are going to address it, how novel letters compared to all these people who have done already earlier. So how to do a search? Already I have shown. Okay, understand the invention under consideration, understand the problem statement or purpose of the search string, depend upon the process, use synonymous or the keywords. Okay, when you are searching, okay, any of the free version, you need to put a keyword. For example, in our case, what we showed is can. Okay, so you need to enter beverages, can, late. Okay, so those keywords or the key names you need to enter and make sure, okay, it is getting narrowed down. Okay, we'll do in the Google search, right? So whatever we need, for example, toothbrush, we type in this one, okay, called toothbrush. Okay, Rudresh will be showing on how to do this search and all. Okay, hands-on training will be given. So I'm giving it just overview, so that once we give the hands-on training, okay, you will get more confident on the how to do a search also. So all these things you need to follow: drawing, synonymous, okay, claims, everything should be available. This is how to do the search. So these are the search databases. Okay. So for example, European Patent Office. For example, your idea, you are going to apply a patent in Europe. For that, okay, you have a special a link, okay, where you need to do a patent search in the European Patent Office itself. If you are applying for Europe, but you are doing a search in Indian Patent Office, that is invalid. That doesn't hold good. You are applying for a European, you need to search in the European Patent Office. And the same, okay, US also the same. INPAS is the Indian Patent Office. So when we are applying a patent in the Indian Patent Office, you need to go for INPAS. And this is the website ID. Okay, if you type INPASS in your Google, it automatically goes to the Indian patent search. If you are applying for an Australian, you need to go for the Australian patent office link. There you need to put a keyword and search whether your idea or the concept is already available or not. Okay, these are the links. And in the search databases, okay, non-patent literature. See, I told you in the once you receive a FER, okay, so they don't do a search only with respect to the patent, whether the same patent is already available or not. Even they do a search in the handbooks for the publication, whether the same already it has been published in the handbooks, textbooks, or encyclopedia, or technical reports, conference proceedings, or industrial reviews, or data sheets, blueprints, magazines, or websites, newspapers, everything. Okay, the paid version has a link or the connection between all this non-patent literature survey search also. It captures all the data available in the newspaper, blueprints, everything it tries to capture, but it is not available in your pre-search. Whatever the link I showed here, okay, this holds good only for the patent search, not for the journals and then the newspaper or any magazines. Okay, but the paid version, what the experts are doing in the patent Indian patent office, they have the capability. The search engine has the capability to capture all these things, and the same thing they are going to capture and send you in the FER, first examination report. So if your idea it is already available in the patent, they are going to put, okay, this is already the patent available. Okay, so what exactly is your novelty? And they also put a journals and all textbooks, everything, and they will say, okay, already this has been published. That is the reason I told you, if you have already published a journal also, even after that you can apply a patent, but that is not advisable. If you are done and if you have done this mistake, okay, what we need to do is, you have published a journal and you applied for a patent. What is the time period? You need to say, okay, around 3-4 months or 6 months or 1 year down the line. Okay, you need to say, like, if it is 1 year, see, during this 1 year, we have done lot of innovative modifications or the changes in this, and that we are going to protect in the patent. That is the reason we published the journal. Later we thought, okay, some progress we did, and we found that there is a novelty. Then we went for the filing of a patent. That should be the answer, and you need to give a proof also. So if proof whatever you are submitting, if it is valid, then they clearly sees and that's for the validity. Okay, and then they approve. If it is invalid, okay, whatever you say, it is invalid, it is against whatever you are saying, then they will try to reject your patent. If it is novelty, if you are novel, then they go for the patent filing. If it is not, they are going to reject the thing. Okay. So, any doubts till now? It is clearly understood, right? So whatever the example I gave, okay, the similar example related to your area, you can come with the drawing and you need to explain what exactly is the problem and how you are going to give a solution for that. That is simple. Any doubts till now? So if any question you can ask. So hands-on experience will be given. Okay. So my friend Rudesh is going to open a link and he is going to give a keyword and show how it can be searched. Right, sir? For example, what you are saying is, okay, there are different components which already have been patented, and
compass, my watch,
The camera is completely uncovered products are there. How can it comparing one product and patented as Apple?
Okay, the entire Apple phone is not patented. The technology is patented. They won't, sir, they are not applying a patent on Apple iPhone 7, iPhone 11. Not like that, okay? The technology is in what it is included in that iPhone 6, 7 or 11, okay? That component or that particular software has been patented. Not the complete iPhone 11 is not patented. The components or the software or the technology inside that phone, individually it has been patented and it is protected.
That apps are there because they think just there.
Sir, there are paid software and unpaid also, right? So whichever the software inbuilt in any phones, okay, that already that particular company have protected under the patent and that as a royalty these people are giving it. Understood, right? Whenever iPhone 11 has been sold 10,000, 20,000, 1 lakh units, okay, that particular company which that app has been developed, the royalty will go to that company. Clear, right? Okay. So any other doubts? Okay, if any, no doubts, okay, we'll be here itself for the entire day. You can come in the later. Thank you. So, thank you very much, Praveen. So, wonderful. The session was very wonderful and fruitful. So, many of us, we have an idea. Okay, so how these ideas are going to be converted into the framework, how these ideas are going to be converted into patent, right? So friends, so many of us are knowing that we are always looking into chat GPT and all those things. So friends, if you have an idea, you don't search your ideas in your chat GPT. Okay, because what it will do, so many of us we don't know, and many of you might be knowing, not knowing that how the chat GPT will work. Okay, the chat GPT will work based on your input only. Okay, suppose for example today, so I want to name a hero, like for example, Navi sir is a hero in RCU. Suppose if suppose I am entering in the chat GPT, Professor Navi sir is a hero in Rani Channamma University. Tomorrow, if you are searching who is the hero in Rani Channamma University, it will use the Professor Navi sir is the hero of the Rani Channamma. So friends, so whenever you will have ideas, whenever you will have a new things, you just don't go for your chat GPT for asking, is it a new idea? Is it a novel idea? Okay, so you please don't do the chat GPT searching here. So wonderful, Praveen, you have already discussed about the so this is what exactly the patent is going to be done. So in the first slide only, this is a very informative slide. So what is the title, what is the invention, what is the claim? Okay, so as our research paper, as we are doing a research, the same thing in the patent also. So, but in a patent, it is a very, very specific here. What is our claim? Okay, what is our invention? Okay, so that is what exactly the Praveen is going to share you. I think the next session is going to have the Dr. Rudresh. So he is going to have some hands-on session on how to search the patent, how to search the ideas and all those things. So friends, I think even the Rudresh is going to put some words or you can say some highlights for the social science also. So because many of our research scholars are related to the even languages, even other subjects. So you please focus on how the patents are going to be served and how the patents are going to be filed for the even social science also. You please go take care of those subjects also because our workshop is all multidisciplinary and interdisciplinary subjects we have. So I think the next session is going to handle by Dr. Rudresh. You want to say something? Okay. What sir mentioned is absolutely right. Okay, never try to use ChatGPT. Okay, because whatever the idea you are going to apply for a patent, it is novel. say that novelty you will lose. Correct, right? Say all this chat GPTs, deep sync, and all other softwares, okay? It is built by Chinese or some other company. Okay, whatever we enter, that loses the novelty. So you are telling to the whole world, okay, your novelty, what you are going to apply to everyone. So at the background, what is happening is, okay, these people, okay, they are capturing. See, whenever we type anything in the Google or in the chat GPT, if it is having in a library, it will show from its library. If it doesn't have in the library, okay, it captures all the data and gives the people who is working at the back end, and they will come to know what exactly people are doing and which is the technology it is running, and they will start working on that technology. See, don't use this chat GPT and all other things. We will lose our novelty. We doesn't want the world to know what exactly we are doing. So make sure, okay, once you, especially with the patent and in the journal, never put anything in the chat GPT. That is not advisable, because we will be losing our novelty, and definitely people will try to see all data are capturable at the back end, and people can do much better things compared to us. That is the reason all these developed countries have developed such software, and they are making us like a idiot. Once we enter everything in the chat GPT, so everything we are giving to the other people, they will start working on that. So never do that. Okay, it's not advisable. So thank you, sir, for that.
Good morning once again for all the participants. So, how many understood how to draft a patent completely and how to search? What is the importance? Why I am asking, because only few people ask the doubts, but there are many things in that, right? For example, Sir said, so we need to concentrate on social studies. So there is no specific subject-wise patents. It's based on the novelty, that's all, right? So it may be anything. Even for example, in the beginning, in the yesterday's when I was explaining different rights on IPR, even an agriculturist or farmer, right, who doesn't know what exactly the education is, actually he will also be a patent owner. But we are not knowing that whether he has invented something. For his problem, right, he may be done some adjustment to his devices to solve the problem, and it may be new, which is not known to the world, right? That can also be a patent, right? So majorly we need to check, first of all, in the previous presentation what the Praveen said, I just want to highlight only a few things, especially on drafting. So whenever you get an idea, right, we have seen already in the presentation overview of intellectual rights and patent filing procedure. You know, right? Patent filing means first, in order to file, we need to draft it. It's not like a journal, it's completely different. So first we need to draft. Once it is draft, with 1,600 rupees fees, we can file a patent. Okay. So filing is, once you file it, you will get an application number. Okay. But it will be not published. So you have to wait for 18 months of time, that is 1.5 years. But if you pay the early publication fees of 2,500 rupees, they will going to publish within 1 month. Right? So publication you already see. Right? So once it is published, we need to apply for examination. Right? Means in order to get the grant. Why we need to publish? Because some other country or some other state, the people are doing the same research. Right? They want to know, in order to apply the patent, it should break the novelty. So once it is published, they can search in the patent database. So already some work is done on the same thing and it is published. Means some inventor already applied the patent. So to make the lose of novelty, we need to publish. Publishing is not the grant. You will not have the right anything. Only to tell the world that already some inventor has done, we need to publish it. So once it is published, we apply for examination, right, with a fees of 4,000 rupees. So they will go into the examiners, right? And there is huge opportunity, especially for the students. I'm telling you, I will show this one also. Website of IPR, MSc Physics, MSc Chemistry, right? You will going to get easily jobs on patents. Why? Because yes, we are filing the patents in lakhs and lakhs of numbers, right? And in the government, there is a scarcity in the examination office because, as I South Indian last presentation told, right? Chennai is the patent office for the complete South India. There are very less number of examiners to examine the patent. So the central government hire every 6 months. They will conduct the examinations, right? And if you tackle that examination, you will get the appointment. Central government employability, right? Even MCA students, all master degree students with respect to certain fields, especially science and engineering, not with respect to arts and commerce. Okay, science and engineering. So they will go into all science disciplines, even biology, botany, all departments. Okay, and computer science. Okay, all will get very good opportunity. That is very high. The cadre also you can see. I will show the patent website. Okay. So huge opportunity, especially for examiners. If you tackle the examiner, you will also become one of the examiner in patent office, where whenever we file, you people sit and do the examination process. And you will going to issue us first examination report once the examination is done. And based on the first examination report, we need to write how when you go for court, right? In police maybe written so many clauses on against us. We need to object those things in the court. Similarly, whatever the FER came, we need to make them understand there is a mismatch, or I will going to remove one of the claim which is matching. So many arguments we can do, and we can get the patent grant. Right? So patent, once we receive patent grant, that is the document what I will become a owner for that invention. Then commercialization is left to us. For example, even we have 14 patent grants, we could not commercialize too much. Why? Because there may be many things. For example, one of the technology, me and Davangere Professor Naksut, we have gone for HAL and we have presented for some corrosion resistance of aircraft, the helicopter. But they got an alternate solution for low cost. So it could not be commercialized. Right? Maybe the invention is very good, but they have got for the same purpose some other invention for the low cost. So commercialization is left to how we create the business. Right? But grant will give you the ownership of the right? So we got to know the procedure of how to get the grant. So for that first step, what is the first step now? To file a patent, what do you require? Idea. So that next presentation I will do, right? How to generate ideas. Right? Once you already got an idea, what is the next step to get the patent grant? We need to file. So you need to file, we need to draft a patent. So we already seen the steps in draft. What are the steps in draft we have come across? These are the things, right? Title of the invention. And this is not compulsory. Means some of the invention doesn't require drawings. For example, in chemistry, some methodology we have developed, a new method. For that method, there will be no drawings. Okay, this is one of the examples we have given. Okay, but title of the invention should be there, abstract should be there, summary of the invention is compulsory, and brief description of the invention is compulsory. And detailed description of invention is compulsory, and claims are very, very important. Right? Sometimes, if I do not develop a product, if I doing a process, that is methodology. For example, I given right in order to extract the lead from water, I have developed a new methodology. So that methodology can be patented. But the methodology I may not have, only I will be having flowchart, what after what. I will be not having any drawings. So drawing is not compulsory. Okay, it's based on if it's a product, to give clear detail about the product, we need to have drawings. Otherwise, we do not have drawings. But compulsory is title of invention, abstract, background of the invention, Summary of invention, detailed description of invention to understand the examiner what exactly they have done, and claims. Claims is the very important. Okay, for your claim only they will give the grant. What is exactly otherwise all other thing is to understand the claims. So claim is very important, right? So some professor is asking on Apple iPhone, right? In order to understand better way what is exactly the claims, suppose let us say I was the first person to invent this chain. Okay, chain. So I got a grant for this chain. Let us say this is a product. I got a chain. Okay. So Praveen will come next, will apply a patent on that. What he will do? He will put some technology, some linkages, such a way that it can bend. Now it is fixed. So it can bend. So he got the patent only for that claim. The product is same, but the claim is for bending, for whatever the specific. So if this product is sold, I will also get the royalty. He will also get the royalty. And someone will come, he will going to fix some fixture, right, which can be rotated 360 degrees. Right? He will going to get the royalty for that claim. Whenever this product is sold, so we all three get the royalties.
Restructuring the same product.
Same product. Restructuring means claim is important. What I am claiming is, I am claiming it can be rotated, only that part. But it is adapted in that product. So whenever the product is sold, I will get the royalty. Right? So this is how the claims are very important. For that reason, what people will do, if you observe, when Praveen explained this one, actually we have copied only 20% drawings. The part is very simple, one small strip. You would have explained only in 1 or 2 drawings. Why I have explained so many? Actually, there are another many drawings in that patent if I download and if I show you. Okay. What may be the reason we have given many number of drawings? Claims means you will such a way that what the people will do in industry, they will going to download the patent which is already done by someone, and they will look for what claims someone has not claimed. They will draft it and they will put one claim, and so once he get the grant for that, whenever that product is sold, since he missed the claims in that, he will get the sharing of royalties. So in order to avoid, the people will write the claims in such a way that no one can see something and write their own claims. So that is what the claims, important claims are. Right? So whenever we have developed a new methodology or a product, this is how we need to draft a patent. Right? So once the patent is drafted, but again, the thing is we are going to draft a patent, we will file it, I will show it next time. And even the drawing, if you write the hand sketch also, is more than enough. You should leave invention. Actually, a very good job. Okay, people are learning like in lakhs and lakhs of rupees every month. Okay, if you know how to find a patent and how to become a legal agent, okay, you can start your own. Again, you don't require any investment of huge buildings. Nothing. One computer is more than enough to become an agent, and billions of rupees can be earned. People are doing. This is agent examination. Similarly, every 6 months they will call for examiners. Okay, based on they will give the branch in science who will so you can go for use of IPR cell. Okay, so where you will get many agent also. Agent means it's a legal. For example, you will become a lawyer, legal lawyer. That's all. Right? You know, right? In court, even without lawyer also we can argue. Yes, sir. Only we ask lawyer because he has studied and he has, the laws and everything. He can fight against us. Otherwise, even someone has put a case against you, you can defend your own case. Lawyer is not required. For example, in one of the college, when I was working previously for some years, they did not get me gratuity when I left the college. I gone for and I have applied the case and I have not taken any lawyer. I won the case and they have given me gratuity with the interest. Right? So that is what the thing. So similarly, for patent applying and everything, you need not to be an agent also. But if you become an agent, people will contact you more because you know something. Consultant. This is not government job. Agent is approved. You will get on the agent number. Okay, so that you will be identified even for industry and all. The people will choose only with the agent number to apply the patent and all. You can get easily jobs in industries. Suppose, for example, if you are MSc chemistry, some medicine factories or some pharmaceutical industries, chemical industries will be there. Their idea, they want to apply the patents. So they need someone expert to be file and make the patents. So they will call solely on that purpose. Patent text. So if you already have an agent number, you will get the easily jobs. Okay. And examiners. So patent examiners are very huge roll number of every 6 months they will come. Okay, you can just watch this website, N.I.R.F Cell news and things. They will be keep on applying the jobs. Every 6 months they will come. The patent examiners. And you will be the central government employees. Okay. So that's the one about the job. Pardon? For patent agent, degree is enough. Any degree. Even social studies, arts, for agent, it's not. Only the thing is they have to write a written exam. It's a multiple choice. They have fixed marks, 50% they have to get. Once they have cleared 50% of marks, then there will be written exams. That is about the drafting process. How they draft, based on how they draft, there will be number of questions. If they tackle that exam, there will be an interview process. So based on that, they will go. Every year, almost 2,000 agents are getting passed every year. All the degree students, not just engineering. Whatever the degree, there is no limit for degree for agent. But for examiners, in the patent office, for example, Chennai patent office or whatever the other patent office, if you want to become an examiner, only science and engineering, not commerce and arts, all science disciplines. So huge number of opportunities to get the number of jobs. Okay, now because there are huge number of patent applications. For example, the professors who have filed patent 3 years ago, still they have not got, some of them have not got examination report. Why? Because the number of examiners are very less. They have huge number of patent applications to do the examination process. So the government is hiring like anything. And there are many schemes. I don't know, in the morning, Professor Mangoli sir and Gornale sir, we have discussed about the Kapila scheme. Okay. For us, for engineering colleges, we have ACT approved. Okay, there is a scheme called Kapila. You just check it. Anyone, professors can check this one. Whoever. I don't know, because this for this AICT code is important. Okay, based on that only we can register. Okay, whatever for 100 number of patents, they will give the return. If you file today by Rani Channamma University 100 patents, the filing charge, examination charge, early publication charge for 100 examination fees, again they will going to send back to the college of board. I don't know whether because it is developed by Ministry of Education and MOS and AICT combination. Okay, whether it is applied only for AICT affiliated or even universities can apply, I don't know. You can check it. Since you have computer other branches also, whether you are concerned about AICT, I don't know. So we are getting actually, for that reason we are filing every year 100 patents. Even if it is grant or not, we file because all the money will come back to our college. This is what, like that, there will be some scheme for universities also. Because, as I told in the one of the slides, right, we are, what is the number of ranks we are in with respect to IP? What is second rank? So central government is applying more and more to ramp the rank. So more number of applications to be filed. In order to motivate that, these are all the things are given. For school, they are giving. For school, yeah. School innovations, yeah. Okay. So you have many schemes. Means whenever you file, you will get the returns. Okay, fully funded. Okay, that you can check it. This is also one of the options. And there are many schemes. And to commercialize projects also we have. Okay, you can send some links if you want to commercialize. There are many schemes. Means if you have a TR level 3 and already filed a patent, and if you have got the patent grant to make the commercialization, there are many government schemes where they will going to fund to develop the product. So first we have gone through already the patent drafting process. So, but in order to draft, we need to check whether it is novel or not. Okay, but that is the tedious task. For that reason, the attorneys will go into, if you ask any very good attorneys, means banana, there are many organizations. If you ask, they will charge in lakhs, 2 lakhs, 3 lakhs to get up to grant. Why? Because the patent searching is the very tedious task. But actually, we need to neglect at the beginning level. Okay. We need not to aim always to get the grant. At least in order to learn the process of filing, then we will come to know. Right? We have, when me and Praveen started in 2013 to file a patent, why we have come to this field? Because of that problem only. They were asking 2 lakhs, 3 lakhs. Right? So then we started, why we cannot do by our own. Right? We have failed at the beginning. Means we have filed. And we did not know there was a scheme called early publication. We used to wait for 18 months to get the publication first at the initial stage. Then by doing those things, we got through 111 steps every time. We learned many things. Now we have 14 patent grants. So it will come stage by step. So at the beginning level only, we need not to aim for grant. At least we will learn, because since we have schemes, even if you publish the patent, we will get returns. The money completely back, whatever you have invested. Only you have to search with respect to your university, what are the schemes are there through government. But government is giving too much of money, especially to boost the ranking across the globe. They are investing too much. For the schools, they are giving. Because I am there is a concept called school innovators. I am the examiner for my region. They have given 100 schools to me. They will give the applications and they will going to push towards me. And I want to tell whether this can be filed or not. For every school, they are giving money, complete money for 2 patents. At the beginning, for the school level, school students level. The government is giving complete money, filing early public for the school levels. Right? Then obviously university will be having, because to boost the number of applications and to start innovations at the early stage, they are doing from the school means obviously. So universities also may have grants, but I don't know except the IICT. University funding is also means with the self-finance, whatever the budget available. But there are schemes across UGC, reimburse, and Innovation Cell, Institute, full. We got 8,10,000 rupees this year. Whatever we have invested, completely returned from AIC. So what we need to file, so you need to draft it. Right? Once the draft is done, I just know because so if you go for patents, public search, right? You'll go here. You can, for example, if you have filed any patent, okay, and if you want to know the status, what is this stage, right? You can easily check it. For example, I will show recently one of the patents they have granted. Why I am showing this? Because it is a science background. Just check the application number. So always the first 4 numbers in the application indicates on which year you have filed the patent. Right? And the rest is they have given the some serial number. Wi-Fi is little slow. See, for example, in the college, and there should be difference, right? Why we now, previously I was putting my name as an applicant, okay, but when the N.I.R.F concept came, our college insisted us, it will going to give incentive only if college name is applicant. They will give 50,000 rupees for one grant. If I make one patent grant, they will give 50,000 rupees, right? Because it will be accounted very huge marks for N.I.R.F. Very huge mark. If I get one patent grant, it's equivalent to almost 50-20 publications, whatever you do in journal publication, right? So applicant is maybe university name. In addition to university name, you can put your name also, not a problem. And inventors is whoever your work, even if it is 15 number of inventors, you can put. The fees will not change, the same fees, right? So whenever you check the status, you will get to find application number and ordinary application. What do you mean by ordinary application? We have discussed in the private slides, right? If you are applying the patent in India only, we have not applied anywhere else in the world. We always use ordinary application. Conventional application means I already applied in US. Second time I am applying the patent in India. So usually now we follow only ordinary application because we are not patent filing in any other countries. Title of the invention will be mentioned and the field of invention, okay, and mail ID. And when we applied the patent, when we applied for examination, when it is published, when they have issued the first examination report, you can check, right? 1 week before this, we have applied for, so after we applied the patent on 17/7/2023. It was published within 2 months. Okay, maybe during that time, any number of publications, so they have taken 2 months. Otherwise, within 1 week also it will publish. Then, after examination, they will issue first examination report. Almost 1.5 years. 1 year, 4 months to issue first examination report. Right? Then, for that examination report, I have replied with answers and whatever within 2 months. Right? Then after they have not clarified, they have got call for hearing. Okay, I will show you that also, hearing. So hearing means again virtual meet. So we will going to again argue. So based on that, they have issued the grant. Okay. That is 9th June, they have given me this year, June 2025, they have given the grant. Okay. So if you see, so it will be, the steps will be in the green mark. If you have filed and if you have not applied for early publication, it will be only, it will show green in the file. All other will be in grey color. That today you publish, so today you apply for a patent. It will be, the time will be registered, date, month, year, hour, minute, second. Next second you apply for.
But how many people lost
only on the date. For that reason, whenever you take the printout of your journal, received date will be there. Why? Because for this reason only. That received date means whenever you applied for a publication, that date should be after the patent filing. Today you have applied for patent filing. Next tomorrow you can send for the publication. Because I will have this request for examination, right? This date will be there. Today, 17/7/2023, I applied. During that time only, I paid the examination fees. If I send to the journal, it send 18/7/2023. Not a problem. Because that received date will be 18/7/2023. So first I applied a patent, then for a journal. Right? So patent is always based, stamp based. right? You know who have invented telephone? We have told, right? Graham Bell. Actually, Graham Bell also is one of the research scholar in one of the lab. If you search in Google, there are two inventors for that. But 20 minutes, because during that time there was no internet. Graham Bell first applied the patent 20 minutes before to the another inventor in the same lab who is doing the research. So he got the rights. Because first come, first serve basis. They will not check who is invented, who applied. The patent will be always given based on who applied, not who invented. Okay. So the green color will be there. RQ file means request file for examination. Published. Under examination will be grey and the patent status will be under examination. Means still the examiners have not examined your application and they have not sent the first examination report. Once under examination is there, it is in hearing or FER they have filed, still they have not read the FER. Dispose means either they have rejected or granted. That will be so. So my case is disposed. Disposed means everything is over. That is granted the application with the patent number 567265. That is an application number. This one. When I do the application, I will get application number. When I get the grant, I will get the grant number. Okay. If you go for whatever the documents we have uploaded, everything is open. If you have filed someone, I can see. If I know the application, whatever. Because once it is filed, you will be the inventor. And no one can copy because novelty will be lost. Because they will be having the database. So it just shows, right? So how many, for example, in 17/7/2023, during filing, whatever the draft we have seen, right? Abstract, title of the invention, that thing we have done, we have uploaded. In addition to that, we need to upload some forms, right? Means first is form 1, that is who is applicant, who is inventor, what are their names, what are the designations, contact numbers, email ID, right, signatures, that is the form 1, right? And form 9 and form 18. Form 9 is early publication, right? Means if you wait, it will be for 18 months. If you apply form 9 with a fees of 2,500, it will be published within 1 month. Form 18, request for examination, right? So these things are mandatory. The draft of a patent with the drawings, claims, all those things. And form 1, 980, where form 1 indicates the applicant inventor details, form 9 is early publication, form 18 is examination. So during that day only I filed everything, right? So if you see, this is our draft initially. Maybe initially we have, due to some urgency that we have drafted very weak only. Okay, we have drafted something. I think Manjana sir will get to know easily because he is also chemistry background. So one of the heavy metal, for that reason I used to say like heavy metal removal, heavy metal detection, right? So development of one of the cost-effective sensor, okay, for heavy metal mercury detection by electrochemical sensor. So this is what we have filed with abstract, what is the field of invention, background of the invention, okay, summary of the invention, brief description of the accompanying graphs. Instead of drawings, we got graphs, right? So based on the graphs, then detailed description of the invention, okay, and claims. What are we are claiming? What exactly we are claiming on the invention, what we are doing. So this is the draft. And separately, whatever the drawings means, here we have graphs. Okay, whatever the characterizations we have done, because we used to mention that things in our inventions, we used to mention those figure numbers and in the explanation we used to give what the figure 1 indicates, what the figure 2 indicates, everything in the explanation. There you need not to describe anything in the drawings, right? We used to put drawings. So this is just a draft, okay? And with all other form 1, form 9, form 18 to, as I told you, right? That form 1, 9, 18 fixed template. You need not to, it is available in the website, right? Then, what they do, since we have applied, first we have done filing, they will get the application number, it will be published, we will get the published copy. Then we have applied for examination. After 1.5 years, they have issued me the first examination report, FER, right? How it looks and what are the things will be there. First examination report. And meanwhile, I told right publication. Okay. Once you file a patent, you need to check. You will get a message once it is published. So where you will get is in the publication in the website, journals. Okay. Here if you go for patent journal, every Friday 6 o'clock, whatever the number of things they have seen, they will go into every 6, because you can observe every week it will be there, right? Every Friday evening, okay, it will be published. Sometimes since your application you have filed on Monday, if the number of applications within limits, the examiner they have checked all the whether they have uploaded form 9, 18, everything they will check, and they will going to make the thing and they will going to publish. Whatever you put, they will publish. They will not check novelty, inventive step, only the examination step they will check. This is publishing means someone has applied on this thing. Okay, so that it's to lose the novelty. Granting and all they will do only after examination. Provisional registration. That's a provisional registration. Right? Every Friday evening you can go and check. If you click on this, you will PDF open. There will be bunch of publications across the India. Right? If you search your application number, you will have to get that page. On which page it is published. Okay. So then examination is done. They will give you the first examination report. It will be like this. First examination report issued by the examiner. Okay. Since the number of, actually Chennai is the patent office for us. Since number of application is huge, based on the specialists available. For example, chemistry people are very more number in some other Mumbai. What they do, they will divert those number of applications to them. So they also examine. Okay. Previously it was not like that. Only Chennai office. Now since huge number of applications, they are branching even for another thing. So it will look like this. Okay. Means the date of dispatch of first examination report. This is very important. Why? Because within 6 months you have to reply for this examination report. If you don't reply, again it is invalid. Whatever you have done, you will have only application number published. You will never write the grant. Within 6 months, you need to file the response for this. Right? So they will address to me, whoever filed, right? And they will issue. Okay, on what of the class they are putting this thing. Okay. Date of filing. Okay. And since we have two inventors, Surendra and me, right? See, now, if we check, actually according to this, they should not have given the grant to me. Okay. 3 things they will check. What is that? Inventive steps. Industry, whether it can be applied in industry, means industrial applicability for some purpose. Clarity, definitely. Okay. So, whether these things are there, okay, whether it is lagging on this, and novelty, okay, yes or no. So, based on this, they will going to check these 3 things, okay. And also during the draft, we have missed some signatures, and according to the rules, it's not fit. It means they will going to give the guidelines, how much font should be there, how the drawing should be there. We missed signature, actually, we missed the signature in drawings during uploading. That also they will mention. What are the lacunas in drafting and technical things, everything they will mention. And whether the clients are having inventive steps, they have mentioned no. If it is no, actually it should be not given grant. But we can oppose. That we have done in the reply. Okay, why they are lacking the inventive steps, why it is not clear, everything they will going to mention. At the initially we have also poorly drafted. Okay, and whatever the clauses are there means how it is matching or why it is lacking in inventive steps. They have mentioned one of the US patent and another one is Indian patent. Okay, so they have searched, they got these two patents. Similar to ours, and they are going to describe how it is document given, what it is disclosed. Okay, this document given is US patent. Document D2 is Indian patent. How it is, they are going to explain everything. How they are mentioned as no. Okay, and in the clarity consists. For example, claims you did not understood because our way of writing will be different. What in our mind, he may not understand. Clarity will be not there. So that also explanation he will ask, right? And definitiveness. Okay, and other requirements is with respect to drafting. So they have certain rules and regulations. This should be the font size. This should be the indents. Many things. Okay. If I miss something, they will also have the signatures. Okay. If I miss something, it will also be given in the formal requirements and other requirements. Right? For example, I have not filed the form 2. Right? Complete specification should be built with form 2. I just uploaded complete specification, but I have not included form 2. I miss. Okay. Those things are, even if you do mistake, not a problem. You can do in first exam. Once they give first examination report, we can correct everything and we can upload. Right? So like this, let's see. Actually, our office is Chennai, all southern, but the examiner Rani Kumar and location is Kolkata. He has done, Kolkata office has done my examination. Actually, Chennai should be done, right? But now, because of huge number of applications from all people, they are distributing it, right? And the name of the controller is in Delhi. Okay, because now examiners again higher post, there will be controller. He will going to regulate. He will see and he will going to put. Right? So this will be posted, and based on that, within 6 months we need to put it. Right? So we used to give reply for that. Okay? How, by mentioning all parameters, how it is differentiate from others. Okay, every complete details will be given. Okay, all complete explanation will be given. Similarly, whatever they said, right, clarity is not there on claims. We used to change based on their requirement. We used to change the claims and put it. And if it is my US, whatever you mentioned, US patent. After seeing that, we'll come to know same matching. I have written 6 claims first. I will remove 2 claims. I will write now 4 new claims. So I will going to remove the first 2 claims. So they will going to give the patent grant only for that 4 claims, right? So I will going to make all the changes, whatever they said, okay, and I will going to put it. And during that thing, if you want to add inventor, if you want to remove inventors, if you add applicant, everything you can do. Even the inventor list also you can change, alter, whatever you can do. Okay. So once it is done, for me this they have not, so they have called for hearing. Still they have not got the clarification. After giving the examination report also, still has some doubts. So he will call for hearing. Hearing is they will going to issue one video link. We need to attend. So why they are called for hearing also they will going to mention. Okay. So they will going to mention what my other requirements still they are not satisfied. Okay. So they will going to ask for explanation why you are not done. Okay. So once they call for hearing, we used to put, yeah, I will attend that hearing on the same date, whatever it is mentioned in this one. So what is the date they have called for? They called for on 21/5/2025 and they mentioned the time also. So once you put, yes, I will attend, they will going to send one Zoom link. So based on within that Zoom link, I need to attend virtually. They will ask many questions. If it is satisfied, okay, or else they will ask again to put some written comments for them. So we need to upload the written comments. Then they will intimate for that is granted. Your patent is granted. If it is rejected, they will put it is rejected. Right? So this is the complete set of procedure what we follow for up to grant process. It looks tedious, but actually it's easier than journal publication actually. Right? Because reviewer will ask, you want to do other characterization, many things, they will not ask for characterization and other things. Whatever the claim is there, whether it is matching with other inventions or not, only they will check that one. They will not ask, do that characterization, give me the proof of product development, nothing. So this is the procedure and they will going to give the grant and patent certificate also they will upload. You can download anytime. Right? So this is what the complete procedure for patent. So for this, as we told, right, to do the patent search, that is a difficult task. But at the initial stage, you need not to worry too much. Okay, but you will get many things. Okay, at least to refine the claims and all. I will just show you how to do novelty research. You cannot do that because they use the exam office. They use this orbit intelligence. Okay, this is an AI tool. It's very costly. We cannot buy. So almost every year, the examiners, whatever, for one license, they charge 60 lakhs. Because huge database across the world, they should check. In all the patent database, even from South African countries to US, UK, Europe, whatever the number of countries are there, all database it should check your keywords. And not only the patent database, non-patent literature, that is journals. That database it should search. So it's a huge platform. So it is very costly. We cannot buy. So we can go only for this blue color instead of that red color. Right? Therefore, these three are paid ones. Okay. All three are paid ones. Okay. So these are all easy. It's in their country own patent databases. We can easily go and search. For example, if I go for European patent database, okay, I have given the website. See, if you put some keywords, it will give within the European patent database how many people have done the patent, right? So even for to do the research, this is also very important. Not just checking the journals is important. Even if you check patents, also you will get new ideas for your research, right? So, for example, let us use some daily usage items, right? How many number of patents we have done? So if we search simple, okay, toothbrush. With respect to your research also, I can search, not a problem. Means just to highlight, even for a toothbrush, how many number of patents are there? And with different, right? See, if you just put toothbrush, how many patents will come? How many? 1,63,777 results were found just on toothbrush. One toothbrush, how many patents? Maybe not all commercialized, right? But people used to put it, right? For example, if I go here, okay, and this will collect all, okay, China, Canada, all US databases, etc. Okay, so let us see one US because some other will be on different languages. See, something they have given idea. I don't know for what purpose it may be used. Okay. The superior toothbrush, right? If I go for yes, no toothbrush, right? This something. The design is something. Right? So I can download this patent. If I go for original document, I am able to see this, right? They have given the figure, they have given numbers. In 1937 it is patented. I have not seen whether people have used this one. It may be not commercialized at all, right? During that time, maybe the limits, 1937, only 2 pages with explanation, right? Similarly, you can find very new, let us say, China patent, CN, Chinese, you will find lot of Chinese patents, right? But if you download that, it will be in their language, original document, Chinese language. But conversion also is possible, but you cannot download the original document. Individually you can. Some invention they have done on cleaning of whatever. Tooth cleaning device. Like that, if you find your own problem, you will find hundreds or thousands of patents. And you can check, at least at the initial stage of research, whether it can be granted or not. Or very closely if it is matching, so how your work is different from theirs. If you understand, it's more than enough. So like that, there are n number of databases. Okay. So I urge you to check only these two. What is that? SPSN and BPO is more than enough. These two databases. Free. These are all free. I am not marketing anything. It's free. All these blue colors are red, free. Only the red color are softwares where huge cost. Paid also. And we cannot buy it. The cost is too much. So, even to make very rigorous research, it may be tedious. At least you will get an idea, right? At the initial stage of filing, whether the same, if you give the title, if complete title itself is matching, you are going to get, already people have done. And by reading the claims, for example, if I go to China, you will not understand. So, method of manufacturing a brush and brush. What? Manufacturing a method of manufacturing a brush and brush. Okay, something that given. So, if I open it, the original document, okay, it's filed in 2020 by the company name called Sl.No Toothbrush Industrial Limited Partnership in Japan. The Japan people, they applied the patent in US. Why? Because they may be found that thing should be protected in US to manufacture it. Right? So if you see, they have given drawings, details, means method of manufacturing a brush, how they manufacture, the method of manufacturing, how the bristles will be inserted, a complete explanation. So they have not done on brush, manufacturing method, process. Right? So they have indicated background, field of invention, then summary of the invention. And with the background, they can indicate citations also, means already available patent and how it is different. Summary of the invention. If you do not mention, also not a problem. Then description of drawings, detailed description of the invention, right? And majorly the claims. Here, from where the invention claimed, what they are claiming. This is very, very important. They have claimed 17 claims. First is independent claim and all other dependent. It's dependent on claim 1, claim 2, claim 3, claim. So they have written detailing, right? What exactly the method is. So they will get the grant for this number of claims. So at least while searching, we will get to know. For example, let us say I would develop a new methodology. Okay. Little difference is there between this method and that one. So I will ignore all these claims. I will put only that claim how it is different from that method and my method. So they will get the grant only for my patent, only for that claim, not this for 17 claims. One claim I have written, which is new, as I explained the chair, right? Chair is a product, small invention I am doing on that again, right? Application. For that claims I will get. So if this methodology they have adopted, one of the small thing changes I have done, right? For that changes, if some company adopt the total methodology, they have to give the royalty for me for that special claim. That is what the patent is. So search is a tedious task, I know. So at least you can do this basic keyword search on the available free resources to make it patent draft easy. This is about the patent. Any doubts or anything you want to show? Because if you done hands-on only, you will also feel it. By seeing, you may just only get the importance. But if you start doing the hands-on, it will be easy only. And actually, whenever I say, it is easier than making a journal. So journal plagiarism will come, anything will come, right? Here they will not search for plagiarism. They will check only for the client's resemblance, how the inventive step is same or not, right? Those things. Only 3 things you have to prove. It should be new, it should have inventive steps, it should have industrial applicability. If you prove that, you are going to get the grant. But commercialization is left to you, right? For example, how many, whatever the toothbrush we have seen, 1,63,77 inventions. How many are commercialized and getting money? We don't know. Maybe thousands. That one is a social science way. That again,
I think under your guidance,
if you go through this, okay, I'll show again. If I go here, patents, facts, you download one, frequently asked questions. The same thing we also displayed. Okay. What type of inventions are not patentable in India? So if you say, for example, methodology of survey, you want to do some survey of cash survey, right? Or whatever you want to do. Okay. So the methodology, what you have done, okay, whether it can be patented or not. Okay, since I have not done on that, even I don't know. Okay, so we can go through here. There will be hundreds rules. Okay, so for example, what type of inventions are not patentable? I think we have given all 16, right? The inventors relating to atomic energy, right? Topography. If it is not, whatever the methodology you are telling in the social studies, if it is not falling in the 16 categories, you will get the grant.
Only the data.
Business methods. For example,
Because the statistics has to be a mathematical.
okay, that one. If it is not falling within the 16, you can get the grant. If it is falling within 16, you will not get the grant. That's the important thing. So, for example, business method. I have an Amazon app, right? That whatever the method they have adopted, that cannot be patented. It's a business method, right? How they attract the customer. For example, I will give some incentives, some discounts. Okay. So, giving a discount is also one business method. So, whether giving a discount, if it is patented, no one can copy that business method. It's not possible. For that reason, government has given regulations on what cannot be patented. So, you want to check these 16 points. Whether your thing, it may be in any subject. Okay, because even I am not expert in all other subjects. I may be good in engineering and little bit science because I am doing from past 10 years. But if I ask social studies again, I got grant. What the social studies people are doing, I don't know. Right? So it depends upon the expertise field. So if you are falling within these 16 categories, you cannot buy. Yeah. The same thing we have put it in the slides. The 16 statements. Computer programs also. If I write one program and if I ask to patent, no, it can be copyrighted. It can be copyrighted. So, whenever you buy softwares, everything is copyrighted, not patented. It comes under copyrights. So, I say, right, 60 lakhs for that orbit. It is copyrights. They will give one user, for one user, that is copyrighted. So, with that license scheme only you can operate. Right? For example, antivirus software. If you see that behind, it is copyrighted. The software is copyrighted, not patented. So you will issue the license keys, individual license keys. So based on that, they will earn the money. Right? So you cannot copy what the programs inside that is illegal because it is copyrighted. With that program only the software will work. So we need to know what cannot be patented. So you can search whatever. So social science means you cannot do on, let us say, on the survey methods. But I told, right, one small video we have shown that what I'm making. For that you don't require any science brain. You don't require an engineering brain. Right? Very small thing, whatever the problem you are seeing, okay, if you have some ideas, put it on manual drawing, you can apply for the patent. Right? So, at least to...
ಸರ್ ಒಂದು ನನಗೆ ಮಾತನಾಡ್ತಾ ನನಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಯ್ತು. ಇಲ್ಲಿ ಪೇಟೆಂಟ್ ಬಗ್ಗೆ ಮಾತನಾಡ್ತಿರೋರಿಗೆಲ್ಲ ಬಟ್ ಸೈನ್ಸ್ ಮೆಥಡಾಲಜಿ ಬೇಸಿಕ್ ಅಂತ ಮಾತಾಡೋದು ಒಂದು. ಈ ಸೈನ್ಸ್ ಮತ್ತೆ ಸೋಷಿಯಲ್ ಸೈನ್ಸ್ ಮತ್ತೆ MSW ಈ ತರ ಸಬ್ಜೆಕ್ಟ್ಗಳಿದ್ದಾವೆ. ಇವೆಲ್ಲವೂ ಕೂಡ ಮಲ್ಟಿ ಡಿಸಿಪ್ಲಿನರಿ ಅನಾಲಿಸಿಸ್ ಡೆವಲಪ್ ಆಗ್ತಾ ಇದೆ. ಈಗ UGC ಮಾಡೋದು ಅದೇ. ಹಾಗೆ ಮಾಡ್ತಾ ಇದ್ದಾಗ ಈ ರಿಸರ್ಚ್ ನಾವು ಮಾಡುವಾಗ ನಾವು ಹಲವು ಸಬ್ಜೆಕ್ಟ್ಗಳನ್ನ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿಕೊಂಡು ಅನಾಲಿಸಿಸ್ ಡೆವಲಪ್ ಮಾಡಬೇಕು. ಅದ್ರ ಮುಖಾಂತರ ನಮ್ಗೆ ಏನಾದ್ರು ಒಂದು ರಿಸರ್ಚ್ ಮೆಥಡಾಲಜಿ ಗೊತ್ತಾಗುತ್ತೆ. ಆ ಮೆಥಡಾಲಜಿ ಅದ್ರ ಮೇಲೆ ನಾವು ಪೇಟೆಂಟ್ ಪಡ್ಕೊಳ್ಳೋದು ಹೇಗೆ. ಈಗ ಅದರ ಪರ್ಸನಲ್ ಈಗ ನಾನೇ ಒಂದು ವಿಷಯ ನಾನು ಅನಲೈಸ್ ಮಾಡಿದ್ದೀನಿ. ಈಗ ನಾನೇನ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರೆ ಈ ವೇದ ಉಪನಿಷತ್ತು ಪುರಾಣಗಳು ಈ ಧರ್ಮಗ್ರಂಥಗಳು ಈ ಲಿಟ್ರೇಚರ್ ಫಸ್ಟ್ ಪ್ರಾಚೀನ ಇವೆಲ್ಲವೂ ಸರಿ ಆಧುನಿಕ ಲಿಟ್ರೇಚರ್ ವರೆಗೆ ಇಟ್ಕೊಂಡು ಮತ್ತೆ ಫಿಸಿಕ್ಸ್ ಎಕ್ಸ್ಪೆಷಲ್ ನಾನು ಫಿಸಿಕ್ಸ್ ಮೇಲೆ ಕೆಲಸ ಮಾಡಿದ್ದೀನಿ. ಅದನ್ನ ಇಟ್ಕೊಂಡು ಇವತ್ತೇನು ಗ್ರಹತಾರೆಗಳು ಏನಿದೋ ಈ ಗ್ರಹತಾರೆಗಳಿಗಿಂತಲೂ ಹೆಚ್ಚಾಗಿ ಇವತ್ತು ಸೂರ್ಯಕ್ಕಿಂತ ಸಿದ್ಧಾಂತ ಇಲ್ಲ, ಅಧಿಕೃತವಾಗಿ ಹೇಳ್ತೀನಿ. ಅದಕ್ಕೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀನಿ ನಾನು. ಆದ್ರೆ ಇದನ್ನ ನಾವೀಗ ಎಲ್ಲರಿಗೂ ಸತ್ಯ ಹೇಳ್ತಾ ಇದ್ದೀವಿ, ಸತ್ಯ ಅಂತ ಹೇಳ್ಕೊಡ್ತೀವಿ. ಆ ಸುಳ್ಳು ನಾನು ಮಾಡಿದೀವಿ. ಈಗ ನಾನು ಯಾವ್ದ್ರ ಮೇಲೆ ಪೇಟೆಂಟ್ ನಾನು ಲಿಟ್ರೇಚರ್ ಮಾಡಿದ್ದೀನಿ. ಯಾರಿಗೆ ಹುಡುಕಿದೆ ನಾನು ಅಲ್ಲ ಅದನ್ನ ಮಾಡೋದಾದ್ರು ಹೇಗೆ ಇದನ್ನ ಹೇಳ್ತಾ ಇದ್ರಿ. ಈಗ ಲಿಟ್ರೇಚರ್ ಅಂತ ಕೇಳ್ತಾರೆ. ಲಿಟ್ರೇಚರ್ ನಾನು ಮಾಡ್ತಾ ಇರೋದು ಲಿಟ್ರೇಚರ್ ಮೇಲೆ ಇಡೀ ಇಂಡಿಯನ್ ಅಲ್ಲ ಇಡೀ ವರ್ಲ್ಡ್ ಪ್ರತಿ ಭಾಷೆ ಒಳಗೂ ಸಹ ಭಾಷೆ ಈಗ ಆಲ್ರೆಡಿ ಮಲ್ಟಿ ಡಿಸಿಪ್ಲಿನರಿ. ಅದನ್ನ ಹೇಗೆ ಅದ್ರ ಪೇಟೆಂಟ್ ಎತ್ತುದು ಅಲ್ಲ ಕೆಲವು ಸಬ್ಜೆಕ್ಟ್ ಇರ್ತವೆ, ಕೆಲವು ರಿಸರ್ಚ್ ಮೆಥಡಾಲಜಿಗಳು ಇರ್ತಾವಲ್ಲ. ಸೈನ್ಸ್ ಕಾಣೋದು ಒಂದು ಸೈನ್ಸ್ ಬಗ್ಗೆ ಏನಾದ್ರು ಒಂದು ಸತ್ಯವನ್ನ ಹುಡುಕ್ಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ ರಿಸರ್ಚ್ ಆಗ್ತಲ್ಲ. ಅದನ್ನ ಹುಡುಕಿದ್ರಿಂದ ಅದನ್ನ ಅವ್ನು ಪರ್ಸನಲ್ ತಗೋಬೇಕಾದ್ರೆ ಹೇಗೆ ತಗೊಳ್ತಾರೆ. ಅದನ್ನ ಹೇಗೆ ಎಲ್ಲ ಪೇಟೆಂಟ್ ಕಂಪನಿಗಳು ಬೇಕಾದ್ರೆ ಹೇಳಿದ್ದನ್ನೆಲ್ಲವೂ ಕೂಡ ಪೇಟೆಂಟ್ ಅಲ್ಲಿ ಹೋಗ್ತಿದ್ದಾವೆ. ಆ ಪೇಟೆಂಟ್ಗೆ ಬರೀ ಕಂಪನಿಗಳಿಗೆ ಖಾಸಗಿ ಕರಣಕ್ಕೆ ನಾವು ಸಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಹಾಗಾದ್ರೆ ಸೈನ್ಸ್ ರಿಸರ್ಚ್ ವರ್ಕ್ಗಳು ಇವತ್ತು ಯೂನಿವರ್ಸಿಟಿಗಳಲ್ಲಿ ಅಂದ್ರೆ ಸಾರ್ವಜನಿಕ ಎಲ್ಲರೂ ಕೂಡ ಒಂದಾಗುವಂತ ರಿಸರ್ಚ್ ಮೆಥಡಾಲಜಿಗಳನ್ನ ಮತ್ತೆ ಪೇಟೆಂಟ್ ಅಂತ ಹೇಗೆ ಕೊಡ್ತಾರೆ. ಕಂಪನಿಗಳಿಗೆ ಸಪೋರ್ಟ್ ಆಗ್ತಾ ಇದ್ದೀವಿ. ಕಂಪನಿಗಳ ಉದ್ದಾರಕ್ಕೆ ಮಾತ್ರ ಈ ತರ ಪೇಟೆಂಟ್ಗಳು ಡೆವಲಪ್ ಆಗ್ತಾ ಇದೆ. ಮತ್ತೆ ಎಲ್ಲರನ್ನೂ ಕೂಡಿಸಿದಂತ ಸೋಷಿಯಲ್ ಸೈನ್ಸ್ ಹೇಗೆ ಡೆವಲಪ್ ಮಾಡೋದು. ಮತ್ತೆ ಯಾವ್ದು ಕಡೆ ನಾವು ಹೋಗ್ಬೇಕು, ಯೂನಿವರ್ಸಿಟಿಗಳು ಮತ್ತೆ ಯಾವ್ದಾದ್ರು ಕಡೆ ಕಂಪನಿಗಳು ಡೆವಲಪ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನೇನು ಪ್ರಶ್ನೆ ಮಾಡೋದು, ಯಾರ ಚಟುವಟಿಕೆ ಮಾಡೋದು. ಈ ಕಂಪನಿಗಳಿಗೆ ಸಪೋರ್ಟ್ ಆಗ್ತಾ ಹೋಗ್ತಾ ಇದ್ದೀವಿ, ಪಬ್ಲಿಕ್ ಅನಾಲಿಸಿಸ್ ಆಗ್ತಾ ಇಲ್ಲ. ಹಾಗೆ ಪೇಟೆಂಟ್ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀವಿ, ರಿಸರ್ಚ್ ಮೆಥಡಾಲಜಿಗಳನ್ನು ಹೇಗೆ ಡೆವಲಪ್ ಮಾಡೋದು. ಮತ್ತೆ ನಾವು ಈ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಸಂಶೋಧಕರಿಗೆ ಏನ್ ಹೇಳೋದು.
Design thinking and innovation to support human people, human society. ಆಯ್ತಾ? ಸರ್ ಹೇಳಿದೇನು ಅಂತಂದ್ರೆ ಇವಾಗ ಬ್ರಾಂಚ್ ವೈಸ್ ಇದೆ ನಮ್ಗೆ. ಸೋಷಿಯಲ್ ಸ್ಟಡೀಸ್ ನಾನು ಅದನ್ನೇ ಫಸ್ಟ್ ಪ್ರೆಸೆಂಟೇಷನ್ ಓವರ್ ವ್ಯೂ ಆಫ್ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟೀಸ್ ಕೊಟ್ಟಿದ್ದು. ನಾನು ಬರೀ ಪೇಟೆಂಟ್ ಗೆ ಕಾನ್ಸಂಟ್ರೇಟ್ ಮಾಡಿಲ್ಲ. ಏನೇನಿತ್ತು ಟೂಲ್ಸ್? ಕಾಪಿರೈಟ್ಸ್, patents, trademarks, geographical indications, copyright, right, new plant variety. Government has given all regulations to protect all peoples. ಇವಾಗ ನಾವು ಸೋಷಿಯಲ್ ಸ್ಟಡೀಸ್ ಮಾಡಿದ ಅನಾಲಿಸಿಸ್ ಇದರಲ್ಲಿ ಕ್ಲೈಮ್ ಆಗಲ್ಲ, ನೀನು ಮ್ಯಾಥಮೆಟಿಕಲ್ ಮಾಡೆಲ್ ಆ ಬಿಸ್ನೆಸ್ ಮೆಥಡ್ ಕ್ಲೈಮ್ ಆಗಲ್ಲ. ಯು ಹ್ಯಾವ್ ಡನ್ ಸಮ್ ಗುಡ್ ರಿಸರ್ಚ್. Okay, when if it is applicable, if it is usable across the world, make a book, right? Publish it, make a copyright, you will get the royalty. If it is patented, we give it, because it will not come under patent. Whatever the research analysis you have done, whatever the research findings you have done, okay, if it is usable across the world, book, leave a book on that, so that ಇವಾಗ ಸ್ಪ್ರಿಂಜರ್ ಬುಕ್ ನಾವೆಲ್ಲ ಬುಕ್ ಚಾಪ್ಟರ್ಸ್ ಬರೀತೀವಿ. ಸ್ಪ್ರಿಂಜರ್ ಅವ್ರು ಎಷ್ಟು ಕೋಟಿ ದುಡ್ಡು ಮಾಡ್ಕೊತಾ ಇದಾರೆ, ನಾವು ಸುಮ್ಮನೆ ಬರ್ದೇನೋ ನಂಬರ್ಸ್ ತೋರಿಸ್ಕೊಳ್ಳೋಕೆ ನಮ್ಮ ಬಯೋಡೇಟಾದಲ್ಲಿ ವಿ ಆರ್ ಪುಟಿಂಗ್ ಅವರ್ ಎಫರ್ಟ್ಸ್ ಟು ಪುಟ್ ದಿ ಬುಕ್, ಬಿಕಮ್ ದಿ ಬುಕ್ ಎಡಿಟರ್ಸ್. ಐ ಡೋಂಟ್ ನೋ ಹೌ ಮೆನಿ ಪೀಪಲ್ ಆರ್ ಗೆಟಿಂಗ್ ಟು ಬುಕ್ ಎಡಿಟರ್ಸ್ ಆರ್ ಬುಕ್ ಚಾಪ್ಟರ್ ಪಬ್ಲಿಷರ್, ಬಟ್ ಸ್ಪ್ರಿಂಜರ್ ಇಸ್ ಅರ್ನಿಂಗ್ ಲೈಕ್ ದಟ್. ಇಫ್ ಯು ವಾಂಟ್ ಟು ಡೌನ್ಲೋಡ್ ದಟ್ ಬುಕ್, ಇಟ್ ವಿಲ್ ಆಸ್ಕ್ ದಿಸ್ ನಂಬರ್ ಆಫ್ ಡಾಲರ್ಸ್ ಯು ಹ್ಯಾವ್ ಟು ಪೇ, ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ರೇಟ್ ಎಲ್ಲ, ರೈಟ್? ಅದೆಲ್ಲ ಏನು, ಅವನ್ನೆಲ್ಲ ನಮ್ಮ ಹತ್ರ ಕಾಪಿರೈಟ್ ಲಾ ತಗೊಂಡಿರ್ತಾರೆ. He has taken all our agreements, copyright agreements. ನಾವೆಲ್ಲದಕ್ಕೂ ಸೈನ್ ಹಾಕ್ಬಿಟ್ಟು ಎಸ್ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂತ ಓದಲ್ಲ, right? We have given the copyright agreement to them in journal, book chapters, books, everything. They will going to earn like millions of dollars of money because of us. They are just one company will maintain the database of the publication through Scopus, right? So we have tools. For that reason, we need to know all the IPR tools, not only the patents. Patent will be not applicable for all, only it can be applied for methods and products. Methodology, other process, ಮತ್ತೆ ಪ್ರಾಡಕ್ಟ್. ಅದರಲ್ಲಿ ಮೆಥಡಾಲಜಿ ಅಂದ್ರೆ ಏನು, ನಮ್ಮ ಸೈನ್ಸ್ ಅಂಡ್ ಇಂಜಿನಿಯರಿಂಗ್ ಅಲ್ಲಿ ಬರ್ತದೆ ಪ್ರಾಡಕ್ಟ್ ಇದಕ್ಕೆ. ಇನ್ ಸೋಷಿಯಲ್ ಸ್ಟಡೀಸ್ ಮೆಥಡಾಲಜಿ, ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ಬಂದ್ರೆ ಮ್ಯಾಥಮೆಟಿಕ್ಸ್ ಇಸ್ ಆಲ್ರೆಡಿ ನೋನ್, ಸೊ ನಾವೆಲ್ಟಿ ಇಸ್ ಲೂಸ್, ರೈಟ್? ನಾನೊಂದು ಇದೆ ಏನೋ ಆಯುರ್ವೇದಿಕ್ ಟರ್ಮರಿಕ್, ರೈಟ್? ಅದನ್ನ ಆಯುರ್ವೇದಿಕ್ ಅರಿಶಿನ ನಮ್ಗೆ ಯಾವ ತಾತ ಮುತ್ತಾತನ ಕಾಲದಿಂದನೂ ವಿ ನೋ ಹೌ ಟು ಯೂಸ್ ಟರ್ಮರಿಕ್ ಫಾರ್ ಡಿಫ್ರೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್. ಅದನ್ನ US ಅಲ್ಲಿ ಟರ್ಮರಿಕ್ ನ ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಪೇಟೆಂಟ್. ದೆನ್ ದಿ ಮಾರ್ಷಲ್ಕರ್ ಹ್ಯಾಸ್ ಫೋರ್ಡ್ ಫೈಟ್ ಮಾಡಿ ಎಲ್ಲೆಲ್ಲಿ ಟರ್ಮರಿಕ್ ಯೂಸ್ ಮಾಡಿದ್ರು ಇವಾಗ ನಾವೆಲ್ಟಿ ಲಾಸ್. ಸೊ ನಮ್ಮ ಆನ್ಸಿಯಂಟ್ ನಾಲೆಡ್ಜ್ ಇಟ್ಸ್ ಓಪನ್ ಟು ದಿ ಪಬ್ಲಿಕ್, ಎವ್ರಿ ಒನ್ ನೋಸ್ ನಾವೆಲ್ಟಿ ಇಸ್ ಲಾಸ್. ಸೊ ವಿ ಕ್ಯಾನಾಟ್ ಮೇಕ್ ಎನಿಥಿಂಗ್ ಆನ್ ದಟ್, right? Patent intellectual property. Pardon sir? TKDL. A traditional knowledge, that one again. For example, ನಾವು ಹೇಳ್ತೀವಿ ರೈಟ್ ಬ್ರದರ್ಸ್ ಏರ್ಪ್ಲೇನ್ ಇನ್ವೆಸ್ಟ್ ಮಾಡೋದು ಅಂತ. ವಿಮಾನ ಅಂತ ಕಾನ್ಸೆಪ್ಟ್ ಯಾವಾಗ ಇತ್ತು, ರೈಟ್? ಸೊ ರೈಟ್ ಬ್ರದರ್ಸ್ ಹ್ಯಾವ್ ಮೆನಿ ಪೇಟೆಂಟ್ಸ್ ಆನ್ ದಿಸ್ ನೇಮ್. ಅವಾಗ ಆ ಟೈಮಲ್ಲಿ ನಾವು ಫೈಟ್ ಮಾಡಿಲ್ಲ ಈ ವಿಮಾನದೊಂದು, ಯಾಕಂದ್ರೆ ಐ ಡೋಂಟ್ ನೋ ವೆದರ್ ಸಂಸ್ಕೃತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆ ಯೂನಿವರ್ಸಿಟಿ. So because in Bangalore University, one of the professors I meet ಮಾಡಿದೆ, top Sanskrit professors, they could not decode whatever the scripts they have, right? Anta technology Sanskrit book ಅಲ್ಲಿ ಇದೆ, but still they could not decode because we, for some other purpose, because I was working in aeronautical department ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದೆ, ಅಲ್ಲಿ ಯಾರೋ ಪದ್ಮಭೂಷಣ್ ಪ್ರಶಸ್ತಿ ತಗೊಂಡಿರೋರು ಇದ್ರ ಮೇಲೆ ಆನ್ಷಿಯಂಟ್ ನಾಲೆಡ್ಜ್ ಮೇಲೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, how to recreate those things ಅಂತ. So we took that book. However, if that Padma Bhushan Prasasti Vijayendra, he got that book and we got to Bangalore University, famous professor, okay, in Sanskrit department. He could not read and decode those wordings. So ancient knowledge number avagindanu ide. For example, pi value ಹೆಂಗ್ ಬಂತು, ಅದು with respect to 16 digits ಇದರಲ್ಲಿ ನಮ್ಮ ಹನುಮಾನ್ ಚಾಲೀಸ್ ಅಲ್ಲೇ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೊ ಅದನ್ನೆಲ್ಲ ಡಿಕೋಡ್ ಮಾಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ, ಅಥವಾ ನಮ್ಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿಲ್ಲ ನಾಲೆಡ್ಜ್. ಸೊ ಇದೆಲ್ಲ ಏನು ಅಂತಂದ್ರೆ, ಈಗ ನಮ್ಗೆ ಸಂವಿಧಾನ ಬಂದ್ಮೇಲೆ ಸೊ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ಸರ್ಟನ್ ರೂಲ್ಸ್, ನಾವು ಆ ರೂಲ್ಸ್ ಎಲ್ಲ ಇರ್ಬೇಕಷ್ಟೇ. ಸೊ ದಿಸ್ ಆರ್ ಆಲ್ ಅಗೇನ್ ಒನ್ ಆಫ್ ದಿ, ನಾವ್ ಹೆಂಗೆ ಕ್ರಿಮಿನಲ್ ಲಾಸು, ಈ ಲೇಬರ್ ಲಾಸು ಆತರ ಇದೆಯೋ, ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ಒನ್ ಆಫ್ ದ ಲಾ. ಈ ಲಾ ಏನಿದೆಯೋ ಅದನ್ನ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ. ಇವಾಗ ಪೇಟೆಂಟ್ ಅಲ್ಲಿ 16 ಕೊಟ್ಟಿದ್ದಾನೆ, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಇದರಲ್ಲಿ. If it is crossing this, we cannot do it. Right? So next, so maybe it is complex, alva ಏನಂದ್ರೆ ನಾನು ಸೋಷಿಯಲ್ ಸ್ಟಡೀಸ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ, ನಾನು ಲಿಟರೇಚರ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ, ನಮ್ಗೆ ಹೆಂಗ್ ಐಡಿಯಾಸ್ ಬರುತ್ತೆ ನಿಮ್ ಸೈನ್ಸ್ ಅಲ್ಲಿ ಇದ್ದೇವೆ. ದಟ್ ಇಸ್ ಮೈ ನೆಕ್ಸ್ಟ್ ಪ್ರೆಸೆಂಟೇಷನ್ ಆಕ್ಚುಲಿ. ಓಕೆ, ಸೊ ನಾವು ಅದಕ್ಕೆ ಪ್ರೆಸೆಂಟೇಷನ್ ಯಾವ ತರ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂದ್ರೆ, ಫಸ್ಟ್ ವಿ ಹ್ಯಾವ್ ಫೋಕಸ್ಡ್ ಆನ್ ಟು ಗಿವ್ ಯು ಗ್ಲಾನ್ಸ್ ಆಕ್ಚುಲಿ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ರೈಟ್ಸ್ ಅಂದ್ರೆ ಏನು, ಅದ್ರಲ್ಲಿ ಯಾವ್ದಾವ್ದು ಇದೆ, ಕಾಪಿರೈಟ್ಸ್, ಟ್ರೇಡ್ ಮಾರ್ಕ್ಸ್, ಡಿಸೈನ್ಸ್, ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸೈನ್ಸ್, ನ್ಯೂ ಪ್ಲಾಂಟ್ ವೆರೈಟಿ. ಯಾಕಂದ್ರೆ ಎಲ್ಲಾ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಸ್ they want to make their intellectual ideas should be protected to some tools. So intellectual property le ella ide, patents ide, copyrights ide, trademarks ide. So ee patentable barliಲ್ಲ ಅಂದ್ರೆ copyrightable ಮಾಡ್ಬೋದು. So ನೀವು ಡಿಸೈನ್ ಏನೋ ಮಾಡಿದ್ರೆ, ನೀವು ಪೇಂಟಿಂಗ್ಸ್ ಆರ್ಟ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಗಳಿದ್ರೆ ಅದನ್ನ ಏನೋ ಪೇಂಟಿಂಗ್ ಮಾಡಿದ್ರೆ you can do it. ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಮನಿ ಇದೆ ಅಂತ, just if you do some jewelry designs, if you have registered under industrial design, ತನಿಷ್ಕೋ ಅಥವಾ ಲಲಿತಾ ಜ್ಯುವೆಲರ್ಸ್ ಆ ಡಿಸೈನ್ ಇಷ್ಟ ಆಯ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ನೀವು ₹500 ಕೊಟ್ಬಿಟ್ಟು ಆ ಡಿಸೈನ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡ್ಕೊಂಡಿರ್ತೀರಾ, ರೈಟ್? ಇಫ್ ಅಟ್ ಆಲ್ ದೇ ರಿಕ್ವೈರ್ ಯುವರ್ ಡಿಸೈನ್ ಟು ಬಿ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ಡ್ ಎಸ್ ಎ ಗೋಲ್ಡ್ ಆರ್ನಮೆಂಟ್, ನಿಮ್ಮ ಹತ್ರ ಬಂದು ಅದನ್ನು ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರೆ. ಯು ಕ್ಯಾನ್ ಡಿಮ್ಯಾಂಡ್ ಬೇಸ್ಡ್ ಆನ್ ದೇರ್ ರಿಕ್ವೈರ್ಮೆಂಟ್. ನೀವು ಮಾಡಿರೋದೇನೋ ಜಸ್ಟ್ ಎ ಸ್ಮಾಲ್ ಡ್ರಾಯಿಂಗ್, ರೈಟ್? ಬಟ್ ದಟ್ ಡ್ರಾಯಿಂಗ್ ಕ್ಯಾನ್ ಬಿ ಗಿವ್ ಯು ಮನಿ ಇನ್ ಯೂಸ್ ಅಮೌಂಟ್. ಸೊ ದಿಸ್ ಆಲ್ ದ ಟೂಲ್ಸ್ ಆರ್ ದೇರ್ ವೇರ್ ವಿ ಕ್ಯಾನ್ ಯುಟಿಲೈಸ್ ಬೇಸ್ಡ್ ಆನ್ ಯುವರ್ ಇಂಟ್ರೆಸ್ಟ್, ರೈಟ್? ಆಮೇಲೆ why they concentrate morely on patenting, because the accreditation bodies and N.I.R.F ranking, all they ask on more on patent. They will not give the marks for copyrights, trademarks, industrial design marks ಕೊಡಲ್ಲ, ಬರೀ patenting ಮಾರ್ಕ್ ಮಾಡ್ತಾರೆ. ಯಾಕೆ ಅಂತಂದ್ರೆ the government economy depends upon our innovations. ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಸ್ಟಾರ್ಟಿಂಗ್ ಹೇಳಿದ್ದು, ನಮ್ಮ ಎಕಾನಮಿ ಹಿಂಗಿದೆ, ನಮ್ಮ ಪಾಪ್ಯುಲೇಷನ್ ಎಲ್ಲಿದ್ದೀವಿ, ಚೈನಾ ಯಾಕೆ ಮುಂದೆ ಇದ್ದಾರೆ. Why? Because the innovations are more, inventions are very high. Why? Because small product na reverse engineering ಮಾಡ್ತಾರೆ ಅವರು, ಅದ್ರಲ್ಲಿ ಏನೋ ಸ್ಮಾಲ್ ಕ್ಲೈಮ್ಸ್ ಡೆವಲಪ್ ಮಾಡ್ತಾರೆ, ಪೇಟೆಂಟ್ ಮಾಡ್ಕೋತಾರೆ, ಅವ್ರದೇ ಒಂದು ಹೊಸ ಪ್ರಾಡಕ್ಟ್. ಸೊ ಆ ಪ್ರಾಡಕ್ಟ್ ನ ವರ್ಲ್ಡ್ ವೈಡ್ ಪರ್ಚೇಸ್ ಮಾಡುತ್ತೆ, ಅವ್ರ ಎಕಾನಮಿ GDP will going to grow like anything, right? So that patenting culture should start ಅನ್ನೋದಕ್ಕೆ ಇಂಡಿಯನ್ ಗವರ್ಮೆಂಟ್ ಆಲ್ ಅಕ್ರಿಡಿಟೇಷನ್ ಬಾಡೀಸ್ ಅಲ್ಲಿ, ಆಮೇಲೆ they are giving more on weightage on giving a reimbursement for patent filing. ಆಮೇಲೆ ಅದನ್ನ ಕನ್ವರ್ಟ್ ಮಾಡೋದಕ್ಕೆ, ಇಫ್ ಯು ಹ್ಯಾವ್ ಡೆವಲಪ್ ನ್ಯೂ ಐಡಿಯಾಸ್, ಮುಂಚೆ ಏನು ಅಂದ್ರೆ ಒಂದು ಟೈಟ್ಲ್ ಹಾಕ್ಬಿಟ್ಟು ಸ್ವಲ್ಪ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಅದು ಇದು ಅಂತ ಬರ್ದ್ಬಿಟ್ಟು ಪ್ರಾಜೆಕ್ಟ್ ಫಂಡ್ ಮಾಡಿದ್ರೆ ಈಸಿಯಾಗಿ DST, VGST ಇದೆಲ್ಲ ಯೂನಿವರ್ಸಿಟಿ ಸಿಕ್ಬಿಡ್ತಿತ್ತು ನನ್ನ ಪ್ರಕಾರ. ಈಗ ದೇ ಆರ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ ಪ್ರೋಟೋಟೈಪ್ ಪ್ರೂಫ್ಸ್. TRL ಲೆವೆಲ್ 3 ಪ್ರೂಫ್ ಇದ್ರೆ ನಿಮ್ಗೆ 50 ಲಕ್ಷ 60 ಲಕ್ಷ ಗ್ರಾಂಟ್ ಅಥವಾ 1 ಕೋಟಿ ಅದನ್ನ ಗ್ರಾಂಟ್ ಕೊಡ್ತಾರೆ ಹೊರತು, ಇಫ್ ಯು ಹ್ಯಾವ್ ರಿಟರ್ನ್ ಓನ್ಲಿ ದಿ ಥಿಯರಿ, ನಾನು ಇದ್ರ ಮೇಲೆ ರಿಸರ್ಚ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಐ ಥಿಂಕ್ ದೇ ಆರ್ ನಾಟ್ ಗಿವಿಂಗ್ now. So all are expecting TRL level 3. Why? Because ಮುಂಚೆ ಎಲ್ಲ ಏನ್ ಮಾಡ್ತಿದ್ರು, ರಿಸರ್ಚ್ ಮಾಡ್ಬಿಟ್ಟು DST ಒಂದು ಪ್ರೆಸೆಂಟೇಷನ್, ಒಂದು ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿಗೆ ರಿಸರ್ಚ್ ಎಂಡ್. ಬಟ್ ನೌ ದ ಇಂಡಿಯನ್ ಗವರ್ಮೆಂಟ್, ವಾಟ್ ಎವರ್ ದೇ ಆರ್ ಇನ್ವೆಸ್ಟಿಂಗ್ ಇನ್ ರಿಸರ್ಚ್, ದೇ ವಾಂಟ್ ಟು ಕಮ್ ಔಟ್ ಎಸ್ ಅ ಪ್ರಾಡಕ್ಟ್ which can be utilized in industry, in mass production, and which can be useful for the growth of economy of the country, right? For that reason they are asking everywhere. Nam engineering alanthu, if you apply any project with just theory, they will not apply. Whether you already developed something, even if you have made publications on that specific field, proof of concept idya, prototype develop madidya, whether it can be converted into a startup, that are the things. Regulations are there now in all project prospects. So they are insisting more to develop our country through economy, because if you are innovative only will grow, because now we are in knowledge economy, not industrial economy. If you produce huge number of manufacturing, does not contribute to our GDP. We need to make our ideas such a way that, because IT is also one of the huge hub, right? Software, electronics also making too much. So adun bere country or nammanna tagondre, our GDP will increase, not just for only manufacturing, right? So adikoskara we have concentrated on patents. So now we are thinking on how to create ideas, right? So that will be discussed in my next presentation, that is innovation and design. So we will start after the lunch about these two presentations, and the next presentation will be on AI buzzing word. ಎಲ್ಲರಿಗೂ ಹೆಂಗ್ ಯೂಸ್ ಮಾಡ್ಕೋಬಹುದು ವಿತೌಟ್ ಕೋಡಿಂಗ್. ಕಂಪ್ಯೂಟರ್ ನಾಲೆಡ್ಜ್ ಇಲ್ಲದೆ ಇದ್ರು AI ಹೆಂಗ್ ಯೂಸ್ ಮಾಡ್ಬೋದು.
Thank you very much. So please sit down. So we will have some announcements. So just a minute for that. So
Please be seated. This is not the decorum of the meeting. Please be seated.
thank you very much, Dr. Udesh, for a wonderful session on this is how to search the patent, especially the examination report, how the PR is going to be seen, how the compliance are going to be written. So that is how the claims are going to be claimed properly. So you have explained very good with some examples, and already you have focused the two important things. One is an examination agent and another one is an examiner. So these are the two important things. Actually, even we don't know about the examination agent. So now anybody can become an examination agent by applying the post already in a patent. If you go into the patent website, there you will get the advertisement every year. I think so. If I remember, this Amruta already she has written the examination related to the examiner. Okay, may I patent office we have written. So already she has written the examination. So likewise, even the other subjects like the even science subject background already he has told, especially engineering and science background, they can go for this examiner. But all subjects related to the other social science also they can become an agent for the examination. So please go through this website and kindly update yourself by looking into that. So hopefully the next session what we have is innovation design or innovation thinking and how the AI is going to be used for your patenting and even a filing. So next sessions are very important. You please don't miss any session. So as already our Kannada professor has discussed about how the literature is going to be patented and how the literature is going to be taken into a multidisciplinary actually. Yes, friends, even if you look into the computer science, this AI and machine learning, so we need a languages actually. We have a large language models. There we need a Kannada, there we need a Marathi, there we need an English. So all these subjects are involved in the large language models. Only the architecture, only the methodology what we are using. So those are important things. When you look into the searching the patents, if you look into the deeper in the site, definitely you will get the opportunity even for publishing, even for making the copyright, even for making the trademark. With these remarks, I think today's morning sessions are wonderful, both by Dr. Praveen and Dr. Udesh. So anyhow, again afternoon we are meeting all for another two sessions. Two sessions we have. One session I think your two sessions he is going to give. So anyhow, we will finish within 5. The sharp 5 o'clock we will finish 4:30. Okay. So within 4:30 we will finish both the sessions. So after taking a lunch, you please be assembled here at a sharp time. So I think he is going to announce that.
Some announcements have to be made. The lunch arrangement for the faculty members is being made in the Department of Economics, and for guest faculty and research scholars, it is in the corridor. And about the certificates will be provided after the session gets over. And about the attendance, whoever needs the attendance for this workshop, even that will be provided after the session. And there will be a link shared for the feedback of this workshop. We all request you to give your feedback. Thank you.